Yes.
As a matter at court number 1, and also as per the court list, the item number 11 is a part heard. Mine is 8, 9, and 10. So if it starts, then it may take some time. So if your lordship permits, may be taken up after the part 1 matters are over.
Okay. No problem. So where's the other side? You have informed them.
Yeah, I feel for me in the morning.
You call out later, no? These 3, 8, 9, and then after the admission letters.
For motion, item 29.
Please, Your Lordship. Your Lordship, this petitioner is approaching this honourable court through the legal assistance provided by the Netherlands State Legal Service Authority. This is a petition filed under section 528 of the NSS to quash a fire in GR in connection with criminal proceedings in GR number 27 of 2026. In connection with Chantanyak PS case number 4 of 2025 under section 305A of BNS on the sole ground that a compromise has been executed between the parties.
What is the case about?
Your Lordship, it has been alleged that the petitioner has stolen ready-made rubber.
Okay, theft. Will issue notice, let the complainant also appear.
Yes, Lordship.
Your
Lordship,
yes.
If the notice to the respondent number 2 may be permitted to be served
By the state?
by the prosecution, by the public prosecution through the IO.
Through the IO.
Yes.
IO or OC?
IO of the case.
IO of the case. Okay. Anyway, who's accepted notice for the state? Motion.
Your Lordship, I'll accept it. Your Lordship.
Yes. They want the notice on 2 to be served through the IO. Complainant, for the complainant. Okay. The instant petition under section 528 of the BNSS has been filed by the petitioner praying for quashing of the criminal proceedings and the FIR in GR 27/2026 in connection with Changtongya PS case number 0004/25 under section 305 clause A of the BNS. Stop. Para Learned Counsel for the petitioner, Ms. Such and Such, legal aid, appearing as legal aid counsel. Para. The case of the petitioner herein is that after the lodging of the impugned FIR dated 11/11/2025, the investigation had been undertaken and is completed. Investigation completed, no? Investigation completed. So, however, during the pendency of the proceedings, the parties have entered into a compromise. Right? Where is that? Page 32. Right compromise / settlement deed dated 25/5/2026. So, in view of the settlement outside the court, the petitioner has come before this court praying for quashing of the FIR and the criminal proceedings. Stop. Para. Issue notice returnable in 4 weeks. So, Learned PP Ms. Livika accepts notice on behalf of the respondent number 1. Stop. The petitioner shall take steps for service on the respondent number 2 through the IO of the case. The petitioner is permitted to serve the notice on the respondent number 2 through the IO of the case. So the petitioner shall supply extra copy of the petitions on the learned PP for service on respondent number 2.
Your Lordship, if the interim may be considered.
List after 4 weeks, till the next returnable date, the consequent proceedings in respect of GR 27/2026 shall remain suspended.
Till the next returnable date.
Till the next returnable
Yeah,
date.
otherwise, Your Lordship,
Yes.
I have not seen the record.
Yes, it's already stated, till the next returnable date.
Much obliged.
For admission, part third item 11.
Yes.
May I, Your Lordship? Your Lordship, I would like to apprise the court about the brief fact of the case. That is on page number 13 of my affidavit in opposition.
Page 13.
Page 13. Your Lordship, I may be allowed to read the contents of the brief fact of the case. That based on complaint against HPZ token and others, disclosing that thousands of persons were dubbed by this entity on the pretext of receipt of investment for Bitcoin mining, the cybercrime police station Kohima, Nagaland registered an FIR number 3 of 21 dated 8/12/21 under section 420 and 120B of IPC, read with section 66D of the IT Act. 6.2, that offence under section 420 and 120B of IPC fall under paragraph 1, part A of schedule offence. A of the schedule offences under the Prevention of Money Laundering Act. Therefore, the matter was examined by the Directorate of Enforcement, Dimapur Sub-Zonal Office, and since prima facie a case for money laundering as defined under section 3 of the PMLA and punishable under section 4 of the PMLA was made out, a case was recorded by an enforcement case information report via ECIR number this dated 12/4/2022, and investigation was initiated under PMLA. Your Lordship, one FIR was registered before the cybercrime Kohima, and since there was an schedule offence under section 420 and 120B, as because of that the enforcement directorate came into pictures and they initiated the investigation under PMLA. Number 3, Your Lordship, that pursuant of the aforesaid FIR revealed that SPZ token, an app-based token, promised user of large gain return against investment in mining machinery for Bitcoin and other cryptocurrency. The investors were assured that their invest money was being used to buy various mining machines by which cryptocurrency were being mined, and they would be receiving gains against sale of such cryptocurrency. Suddenly, the application stopped working and investors were not allowed to withdraw the money. Your Lordship, the SPZ token apps. So these apps, the investors were asked to invest the money, and many companies, many entities were involved to collect money from the investors. And after investing, when the investors have invested the money, thereafter they purchased the cryptocurrency, and the money was transferred in the wallet, and later on it was transferred to the foreign wallet, and the money was siphoned to many countries. where your lordship, this is an economic offense where more than 10 Chinese companies was also involved. Even the Russian companies are also involved, and the money was siphoned to other country after collecting from the global investors. And your lordship, although initially they were allowed to withdraw the money, the investors. However, after some time, the apps stopped functioning, and the investors were not allowed to withdraw their money. Your lordship, paragraph 6.4. That investigation under PMLA revealed larger conspiracy to cheat global investors and various related entities. Role of similar apps websites were found to be fraudulently receiving funds from public in pretext of unregistered gaming betting loan websites surfaced during PMLA investigation. During the course of investigation, it was revealed that Jyotisha Technology, that is the petitioner's company, your lordship, Jyotisha Technology Private Limited was allegedly involved in activities facilitating fraudulent transaction and deceiving unsuspecting members of the public. Accordingly, the account statement of Jyotisha Technology Private Limited obtained from PayU Payment Service Private Limited and Hypto-In were subjected to detailed analysis. Your lordship, the PayU Payment Service Private Limited, the statement of the directors of PayU Payment Service Limited, their statements were recorded, and through their statement, the investigating agency came to know that Jyotisha Technology Private Limited was also involved in the collecting fund from the publics, and with that fund, they have also purchased the cryptocurrency, and the money was transferred to the foreign wallet. Your lordship, since the suspicions were aroused, then thereafter, Jyotisha Technology Private Limited, their bank account was also scrutinized, and it came to know, the investigating agency came to know that Jyotisha Technology is also doing the same modus of operandi where the HPZ token apps, like any other companies, the way the modus operandi was operated, the same tactics was also applied by the Jyotisha Technology. That is why, Your Honor, they come under the suspicious, and their bank accounts and the statement of their directors, the Jyotisha Technology director, were also recorded, and it has been found that Jyotisha Technology is also involved in the proceeds of crime. 6.6, Your
No,
Lordship.
but how were they connected with that HPZ token company?
Yes, Your Lordship. There are several companies, several entities.
There may be all having the same modus operandi of duping the investors.
Yes, Your Lordship.
So, don't you think a separate case should be filed against each of them?
I'm coming. I will come on that Your Lordship. Now here, I will come that proceeds of crime. Later on, I will come. I will explain this Honorable Court, Your Lordship. 6.6. The investigation disclosed that merchant Jyotisha Technology Private Limited was operating through the website www.astropay.com, which offered prepaid card facility that could be utilized on various betting and gambling platforms. The website was also found to provide services relating to cryptocurrency. Further examination revealed that the merchant was onboarded on the payment gateway platform of PayU Payment Service Private Limited under an e-commerce line of business. However, it was found that the merchant was allegedly misusing the payment gateway credentials, salt and key, by routing transaction traffic originating from betting and adult content website. Analysis of website traffic during the relevant period indicates substantial users activity from China and several other foreign jurisdictions on the website. It was further observed that a significant volume of referral traffic associated with gambling and sports betting transactions originated from websites engaged in betting related activities. Additionally, OnlyFans.com and adult content platform was identified as one of the top referring websites directing traffic to the merchant platform. The investigation also revealed discrepancy between the nature of business declared by Jyotisha Technology Private Limited and its actual operations. The company had declared its business activities under GST as collection agency service and financial transaction processing and clearing house service. The nature of transaction processed through its platform and the business activities conducted through the website did not correspond with either the declared business activities or the line of business registered with PayU Payment Service Private Limited. This finding indicate that the transaction processed by the merchant were not in conformity with its declared and registered business activities. It was observed that PayU Payments Private Limited had placed a hold on the pay-in and pay-out amounts pertaining to Jyotisha Technology Private Limited upon receipt of complaint from the cybercrime police regarding the company's suspected activities. Your Lordship, Jyotisha, the petitioner's company was registered under the PayU Payments Private Limited, and its business activities, which was declared before the PayU, was that it was under the GST as collection agency service and financial transaction processing and clearing house service. However, the line of business was totally different with the registered one. As such, the suspicious has arose, and even the PayU Payment Private Limited also hold the transaction of the Jyotisha Technology, Your Lordship. During the course of 6.11, during the course of investigation, the merchant identification accounts maintained by Jyotisha Technology Private Limited with PayU Payment Private Limited and Case-Free Payment Private Limited, along with the balances available in the associate bank's account, were provisionally attached. Provisional attachment order number 1 of 23. The said attachment was subsequently confirmed by the learned adjudicating authority under the Prevention of Money Laundering Act, wide order dated 35/24. Your Lordship, after the investigations, the Deputy Director of the ED has provisionally attached the property involved in fraudulent transactions, and that was also confirmed by the adjudicating authority. I will also come later on, Your Lordship. They have appeared before the adjudicating authority. They have submitted their defense. However, adjudicating authority has found that there is a discrepancy, and Jyotisha Technology was also involved in the proceeds of crime. That is why the confirmation was made by the adjudicating authority. Now, Your Lordship, these are the fact of the case, how it was involved. Now, I would like to take section 3, under which the case was registered. Page number 9.
Yes.
You notice section 3, offense of money laundering. Whoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in any process or activity connected proceeds of crime, including its concealment, possession, acquisition, or use, and projecting or claiming it as untainted property, shall be guilty of offense of money laundering. Your Lordship, if there is any schedule offense, if there is any schedule offense is there, now any individuals or the companies knowingly or unknowingly, directly or indirectly assist or conceal or acquisition or use or park the money, they also come under the purview of offense of money laundering. It's not necessary that the one who is assisting or who is utilizing the money which was acquired from the schedule offense, he needs to be an accused in the schedule offense. If he assists also, then also he comes under the purview of offense of money laundering. A person shall be guilty of offense of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following process or activities connected with the proceed of crime, namely concealment or possession or acquisition or use or projecting as untenanted property or claiming as untenanted property in any manner whatsoever. Number 2, the process or activity connected with the proceed of crime is a continuing activity and continue till such time a person is directly or indirectly enjoying the proceeds of crime by its concealment or possession or acquisition or use or projecting it is untenanted property or claiming it is untenanted property in any manner whatsoever. So these are the definition of the proceeds of crime, Your Lordship. Now, Your Lordship, I would like to take to section 24. That is on page number 28 of the Act.
Yes.
Burden of proof. In any proceeding relating to proceeds of crime under this Act, in the case of a person charged with the offense of money laundering under section 3, the authority or court shall, unless the contrary is proved, presume that such proceeds of crimes are involved in money laundering, and in the case of any other person, the authority or court may presume that such proceeds of crimes are involved in the money laundering. Your Lordship, that means as per the section 24, if any person charged with section 3, proceeds of crime, the burden to prove that he is not involved lies with the accused. Your Lordship, I would also like to take section 66(2). 66(2), on the last occasion, the Honorable Court was asking about the clarification of 66(2). That is on page 46, Your Lordship.
Yes.
Disclosure of information. The director or any other authority specified by him by a general or a special order in this behalf may furnish or cause to be furnished to any officer, authority or body performing any functions under any law relating to imposition of any tax, duty or cess or to dealings in foreign exchange or prevention of illicit traffic in the narcotic drugs and physiotherapeutic substance under the Narcotic Drugs and Physiotherapeutic Substance Act 1985. Such other officer, number 2, such other officer, authority or body performing functions under any other law as the central government may, if in its opinion is necessary so to do in the public interest specified by notification in the official gazette. In this behalf, any information received or obtained by such director or any other authority specified by him in the performance of their function under this Act. Your Lordship, while investigating this matter, the investigating officer have also disclosed this fact to the concerned police station. That I have the letter which we have. Your Honor, this we have disclosed to the Superintendent of Police, CBI, New Delhi, subject sharing of information in respect of this ECIR This 8622 registered by the CBI CEO. This. Please refer to this office letter dated April requesting to forward certified copy of the FIR in the subject case. We are yet to receive any reply. It is informed that Directorate of Enforcement Dimapur Sub-Zonal Office has conducted searches at 44 locations throughout the country under the provision of Prevention of Money Laundering Act 2002 in September 22, February 2023 and April 2023 and freezed balances available in various bank accounts and virtual accounts held by the suspected entities to the extent of rupees 176.63 crore till date in the above case. Further, provisional attachment order bearing number 1 of 23 dated 22/12/23 to the extent of rupees 278 crore was issued. Total freezing and attachment made so far in this case to the extent of rupees 455.37 crore. Copies of original application and PO filed before the Honorable Adjudicating Authority, New Delhi, with respect to the freezing and attachment of asset, which contains detailed information, and copies of the same are being shared in a CD for necessary action by the CBI. The same letter we have also written to the Gauhati CID, Crime Investigation Department, on the second page, Your Lordship. Also to the Cyber Crime Police Station, Kohima, Nagaland. This is a part of the investigation. If we found, we have to disclose that we have done, Your Lordship. Now, Your Lordship, once again, I would like to take you in PMLA Act, page number 35, as regards to section 44.
Section
44.
Yes.
44, page number 35, Your Lordship, the explanation number 2. Yes. Your Lordship, the complainant shall be deemed to include any subsequent complaint in respect of further investigation.
Where's that section? Section 44.
Section 44.
2.
2. Explanation is there, Your Lordship. Explanation 1 and 2.
Ah, yes, yes.
The complaint shall be deemed to include any subsequent complaint in respect of further investigation that may be conducted to bring any further evidence, oral or documentary, against any accused person involved in respect of the offence for which complaint has already been filed, whether named in the original complaint or not. Your Lordship,
Subsequent complaint. Which complaint? Yes.
Your Lordship, it says that after the confirmation from the adjudicating authority, within 1 year we have filed the prosecution complaint where we made 299 accused. Thereafter, Your Lordship, it is not an end. Now, if there is further any evidence comes, any investigation is not complete there. It is in the continuous process, Your Lordship. Thereafter, if we found further evidence against any accused, and even in the instant case, we have filed a prosecution complaint. Twice we have filed the subsequent complaint. And now at present we have 450 accused in this instant case, Your Lordship. Now, Your Lordship, I would like
Yes.
yes, Your Lordship, I would like to take out page number 735 of the petition, where the statement of the director of Biocon, who reveals that Jyotisha technology is also comes under the purview of suspicious transactions. That
Page 7?
Page 735
In
in the petition,
In
the
part
part
one
2,
or-
part 2. 735, Your Lordship, and next. May I read the statement of His Lordship?
Who is this?
He is the director of the PayU, where the Jyotisha
Okay.
was registered. A statement of Sri Abhishek Botalia, son of Sri Satish Chand, is 31 years, presently working as manager legal and compliance. MS PayU Payments Private Limited, situated at Bestech Business Center, 9th floor, Badshahpur, Sohna Road, Dahini, Tatban Villa, Sector 18, Gurugram, Haryana, and residing at LD 24. Yes,
No, forget the address
Yes,
and
yes,
having such
yes.
and such. Just go to his statement.
yes. Your Lordship, last
name,
five line of the same page. Hence, I am appearing today. You have shown me section 50 of the Prevention of Money Laundering in 2002. I have read the same. You have explained to me that I have to state the truth on any subject in respect of which I am being examined, and I am bound to give a statement and produce such document as may be required during the proceedings. Your question number 2, Your Lordship, page number 736, next page. The question was, Your Lordship, please speak about MS Jyotisha Technology Private Limited and its suspicious activities detected by PayU Payment Private Limited. Jyotisha Technology Private Limited, having merchant ID number this registered with PayU Payment, is a private limited company, was having Dhawal Mukan Vora, director of the company, acting as an authorized signatory. Present director of the above said company are Sachin Minhas and Hari Kishan Lal. Jyotisha Technology Private Limited was registered on PayU platform on August 19, 2020 for availing payment aggregation service through the assisted onboarding process and declared itself to be involved in the e-commerce line of business with the subcategory of online gaming and declared annual turnover amount of 31 crore 20 lakh per annum. Your Lordship, the second para, page number 737, second para, Your Lordship. PayU regular transaction and risk monitoring process indicate certain suspicious pattern in the transaction. It was found that transaction processed by the merchant using PayU service were not in conformity with the declared line of business. The observed GMV, gross merchandise volume, is very large in volume. Merchant has received total volume of 8 lakh approximately captured transactions, wherein majority of the captured transactions are initiated through UPI and wallet, nearly about 98%. Transaction volume, product information and ticket size are not matching with the declared line of business by the merchant. The website used by the merchant is www.astropay.com, which is offering prepaid card facility. It can be used for all betting and gambling website. The website also provides facility of cryptocurrency, which is non-doable business for PayU. It was found that merchant was used PayU platform for e-commerce line of business, but misusing salt and key traffic are being routed from betting and pornography sites, which are non-doable business for PayU. In our analysis, Chinese traffic was seen along with other international countries on the particular website. During transacting month, it was found that top referring website for the merchant is csgoempire.com and 1into001.com, which deals into gambling, sport betting, and also seen another referring website. Due to the above observation, which did not permit the merchant to carry out a business that was contrary to the permitted line of business, PayU was constrained to suspend PayU service to Jyotisha Technology Private Limited with immediate effect and to keep the settlement amount on hold from 12/1/22 in accordance with the terms and conditions of the service agreement. With regard to the above, it was noticed that the merchant provided GST, which shows collection agency service and financial transaction processing and house services as a business, which is not matching the transaction and line of business registered with PayU, thereby confirming that the transaction going through the merchant were not as per the line of business. We have received email from CEN Crime Police Station, Bangalore Rural District against PayU ID for an amount of 750 on 4th August 2022. Another email we have received from Cyber Police Pune City application for fraudulent transaction of amount 1,30,000 and 1,70,000 on 25th August 22. In light of the above, owing to the suspicious nature of the activities of the merchant, PayU has filed suspicious transaction report with FIO Ind on 13/9/20 having batch ID number this. A merchant seeking payment aggregation service of PayU is required to provide details that include the line of business, expected business volume, types of business, options sought, in addition to details in relation to the identity, business address and their relevant information and document as part of PayU Know Your Customers requirement. You'll see on the page number 739, the PayU has two onboarding flows, the online flow and the offline flow. I'll just read the second, the offline flow, the second part, Your Lordship. The merchant Jyotisha Technology Private Limited was onboarded under the assisted onboarding flow, and the KYC and other documents was facilitated by key account manager Mr. Guntuk Sirdar, ex-employee senior key. As per our knowledge, Jyotisha Technology Private Limited is the main beneficiary, but we are not aware who operated the account. We do not have the details of shareholders of the company, and also we do not have KYC for them. This was the statement given by the directors of Biocon and the PayU Private Limited Company, Your Lordship. Thereafter, after recording the statements of the directors, now the director of Jyotisha Technology was called to record their statement, which is on page number 199. It's part 1, Your Lordship.
That we have seen, I think.
Page number 199.
Yes.
8.99, Your Lordship, the bottom. The summons dated 7/6/23 was issued under section 52 of the PMLA to Mr. Hari Kishan Lal, Director MS Jyotisha Technology Private Limited. Your Lordship, on that particular time, he was the director of the Jyotisha Technology Private Limited, and he was examined under section 53 of PMLA. On 10/7/23, in his statement, he inter alia stated that he has passed class 7. Your Lordship, kindly note it down. He has passed class 7 from Sarvodaya Vidyalaya, West Patel Nagar, Delhi, that he was working as field worker for Inaya Forex in Vikaspuri, Delhi, that in the year 2021, Mr. Vineet Misra of Inaya Forex asked him to give his IDs, and which was used to register his name for DIN, that he was appointed director of Jyotisha Technology Private Limited in February 2022, that he is being paid salary of 22,000 per month. He further stated that he used to sign company related documents which were received by him in WhatsApp, speed post or email, that he used to sign and send it back through email after signing the same, that he uses to provide OTP for GST filing received on his phone, that bank account of the company is operated by one Mr. Thomas, who is residing in Argentina, and mobile number of Mr. Thomas is this. He was told by Mr. Vinit Misra of Inaya Forex that as a director of Jyotisha Technology Private Limited, he has to sign the document related to company and provide OTP whenever it is received on his phone for GST filing, that he was offered by him 22,000 per month salary as a director, that he is not aware regarding the actual business of the company. Your Lordship, the director was not aware about the actual business of the company. He stated that he is not aware regarding the shareholders of the company, and he has never visited the office of Jyotisha Technology Private Limited. He was asked to explain who operates the bank accounts and payment gateways account of Jyotisha Technology Private Limited. He stated that as per his knowledge, Mr. Thomas looks after the bank account and payment gateways account of the company, and also he operates the company from Argentina. He also stated that he does not know regarding any transaction with PayU Payment Private Limited or any other companies, and he has never met or interacted with any merchant of gift cards of the company. He also stated that the email ID of the company, legal@jyotisha.com, is operated by Mr. Thomas.
Mr.
Yes.
Gupta, from all this,
Yes.
it is clear that some prima facie case is there against
Exactly.
them for gambling and sports betting and operating some illegal adult website.
Yes,
Okay.
Your Lordship.
But this does not show, all these does not show that the proceeds of the crime in that HPZ token case, which was taken from the investors, that has been parked in their this Jyotisha account. So where does it
no,
show?
Your Lordship, Jyotisha is one of the company, Your Lordship. Now, Your Lordship, a huge money was collected from the investors, and different layers were made. And at the end, when it reached to the Jyotisha Technology, it was converted into the cryptocurrency. It was converted into cryptocurrency, and the money was siphoned to the foreign country, Your Lordship. This is not
Okay,
one
so
of...
according to you, when the investors deposit their money,
Yes.
then that is invested in all these companies.
No, Your Lordship,
Jyotisha.
SPZ token apps, they have used the payment system of these cell companies, and mostly are the dummy companies, Your Lordship. Even the directors are the dummy company, and they have collected this money in a huge way, and thereafter a part was transferred to some other dummy companies, and in this way, after reaching so many layers, it was converted into cryptocurrency, and once it was converted into cryptocurrency, the money was siphoned to foreign origin, Your Lordship. So there is a prima facie case, Your Lordship. Even the directors who were not aware about the line of business of their companies, the class 7 pass, they become the director of such a big companies where the transaction is more than crore, few hundred crore also, Your Lordship. So your Lordship, not only the statement of the director of the PayU that Jyotisha was utilizing their infrastructure for converting the money into cryptocurrency or purchasing the cryptocurrency, even the statement of the director clearly says that they were not aware at all about the line of their business. Your Lordship, their bank account was also seized, and few crore rupees was also found there. Thereafter, the deputy director has attached the property. Now, Your Lordship, the picture will be more clear when I'll say about what is the role of the company in this case. It is on page number 273, Your Lordship. 273.
Yes.
85. MS Jyotisha Technology. These are all the what roles they have in this case. MS Jyotisha Technology Private Limited. The investigation revealed that the website used by the merchant Jyotisha Technology Private Limited is www.astrope.com, which was offering prepaid card facility and can be used on all betting and gambling websites. This is their infrastructure that they are registered for the betting and the gambling website. Yes. The website also provided facility of crypto business. It was found that merchant used Payments Private Limited for e-commerce line of business, but misusing Salt and Key. Salt and Key is used for encrypting and decrypting, while a salt is used together with the hashing to make it even more secure. As traffic are being routed from betting and adult site. During the transaction month, Chinese traffic was seen along with other international countries on the website astrope.com. That is the website of the petitioner's company. It was found that top referring website for the deals into gambling, sport, betting was another referring website, onlyfans.com, which is an adult site. It was noticed that the company Jyotisha Technology Private Limited declared business is collection agency service and financial transaction processing and clearing house service in GST, which does not match the transaction and line of business registered with PayU, thereby confirming that the transaction going through the merchant were not as per the line of business. Therefore, the said company was indulged in parking and routing the ill-gotten money to hide its source, and hence it was directly assisted and associated in money laundering as defined under the provision of PMLA 2002. As revealed during investigation, accused person is beneficiary of the proceeds of crime. Actual person has not only received the proceeds of crime and also came in possession of such proceeds of crime. In the instant case, accused person have knowingly acquired, possessed, transferred, layered, and used the said proceeds of crime obtained or derived by commission of scheduled offences in such a manner as if it was untainted money, and therefore guilty of offence of money laundering as per the provision of section 3 read with section 70 of PMLA, and therefore liable to be punished under section 4 of PMLA. Now, your lordship, can I take on page number 105 of part 1, 105, 5.41, your lordship.
5.41.
That analysis of bank statement of MS Finbucks Solution Private Limited and Quicom Information Technology Private Limited revealed that huge payments are also received from various dubious entities. Huge proceeds of crime layered through these entities have been transferred to crypto exchange Biocon and from there to foreign private wallets. On examination of director of Biocon, it was further revealed that another suspicious entity, Jyotisha Technology Private Limited, had also transacted in cryptocurrency and laundered the proceeds of crime. Therefore, inquiry was made from payment gateways and banks. It was gathered that Jyotisha Technology Private Limited was also indulged in fraudulent activities and cheating gullible people. The account statement of Jyotisha Technology Private Limited from PayU Payment Service Private Limited and Hypoto in were analyzed. 5.42, that investigation revealed that The website used by the merchant Jyotisha Technology Private Limited is www.astroper.com, which was offering prepaid card facility and can be used on all betting and gambling websites. The website also provided facility of cryptocurrency. It was found that merchant used PayU Payment Private Limited for e-commerce line of business, but misusing Salt and Key. This is the same which we have read earlier also, Your Lordship.
Yes.
Now, Your Lordship, I would like to take on provisional attachment order, which was issued against the company Jyotisha Technology. That is on page number 574. That after inquiry, after investigations, the company's assets, bank accounts,
Page.
page 574. Your Lordship, the bottom 3.7. This is the provisional attachment order issued by the Deputy Director. The analysis of bank account of Finbuck Solution and Quickly Limited revealed that huge payment was also received from various dubious entities. Huge proceeds of crime laid through these entities have been transferred to crypto exchange Bicon and from there to foreign private wallet. On examination of director of Bicon, it was further revealed that another suspicious entity, Jyotisha Technology, was also transacted in cryptocurrency and laundered the proceed of crime. Thereafter, inquiry was made from payment gateway and bank. It was gathered that Jyotisha Technology Private Limited was also indulged in fraudulent activities and cheating valuable people. The account statement of GTPL and PU Payment Service Limited were analyzed. Your Lordship, 3.9, 3.8 I have already read in earlier. 3.9, that on physical verification, the company Jyotisha Technology Private Limited could not be located at the registered address. Summons dated 7/6/23 were issued under section 52 of the Prevention of Money Laundering Act to Mr. Sachin Minas and Mr. Hari Kishan Lal, director of Jyotisha Technology Private Limited. Both of them did not appear. Further opportunity was given to them and they appeared on the given dates and their statements were recorded under 50 of PMLA, which are detailed below. That was the statement which I have read earlier, Your Lordship. I will not repeat this. Then 3.40, 3.40. 3.40 is page number 592, Your Lordship.
Yes.
That during the investigation, email dated 13/4/23 was received from PayU Payment Private Limited with respect to merchant account of Jyotisha Technology Private Limited with balance to the extent of totaling rupees 27 crore 46 lakh 46,176. It was seen that PayU Payment Private Limited had put in hold the pay-in and pay-out amounts on receiving complaint from Cybercrime Police for suspicious activities of the company. Similarly, on inquiry, email dated 1/6/23 was received from Case Free Payment Private Limited with respect to merchant account of Jyotisha Technology Private Limited with account balance to the extent of 5 crore 69 lakh 9,545. Further, email dated 7/6/23 was sent to Axis Bank to get details in respect of account held in the name of Jyotisha Technology Private Limited. Axis Bank replied by email dated 13/6/23 and furnished balances held in the account of Jyotisha Technology Private Limited is 11 lakh 50,120. It was seen that Axis Bank had freezed the said account based on complaint received from various agencies. 3.41 that during the course of investigation under PMLA, it was found from the agreement made between the PayU Payment Private Limited and Jyotisha Technology Private Limited that Jyotisha Technology Private Limited has security deposit of 50 lakh with MS PayU Payment Private Limited. Hence, email dated 12/6/23 was sent to MS PayU Payment Private Limited to verify the same. PayU Payment Private Limited via email dated 13/6/23 confirmed that they have security deposit of 50 lakh with respect to Jyotisha Technology Private Limited. Now page number 626, you will see. Your Lordship, page number 626, only that this order was sent to the petitioner's company, MS Jyotisha Technology Private Limited, along with many others company whose accounts were also seized by the Deputy Director. And it is under serial number 9, the Jyotisha Technology Limited. Thereafter, your Lordship, after provisional attachment order was issued, it was sent to adjudicating authority for confirmation. And there, the accused, the director of the Jyotisha Technology, they have appeared and they have submitted their defense. And their reply is on 480, page number 488. 488. That's
488. Yes.
Yes. Your Lordship, this defendant number 11, 12 and 13 are the directors of the Jyotisha Technology Private Limited. In the similar way, some other entities, their directors, they also replied. Your Lordship, in their reply, they have said that no predicate offence is made out against the defence. So I'll go to the operative part, Your Lordship.
Yes.
Observation made by the adjudicating authority at page number 543. 543. 543. This is the observations made by the adjudicating authority. Now your defendant number 11, 12 and 13. The submission made in this paragraph is baseless and vehemently denied. The investigation revealed that the website used by the merchant Jyotisha Technology Private Limited is estrope.com, which was offering prepaid card facility, and the same can be used on all betting and gambling website app. The website also provided facility of cryptocurrency. It was found that merchant used PayU Payment Private Limited for e-commerce line of business, but misused Salt and Key as traffic are being routed from betting and adult site. During the transaction month, Chinese traffic was seen along with other international countries on the website. It was found that top referring website for deals into gambling was another referring website, onlyfans.com, which is an adult site. It was noticed that the company Jyotisha declared business is collection agency service and financial transaction processing and clearing house services in GST which does not match the transaction and line of business registered with PU Payment Private Limited, thereby confirming that the transaction going through the merchant were not as per the line of business. Therefore, the said company was indulged in parking and routing the ill-gotten money to hide its source, and hence it was directly involved in money laundering as defined under the provision of PMLA 2002. Number 2, in terms of explanation under section 21U of the Prevention of Money Laundering Act, the proceeds of crime also include any property which may directly or indirectly be derived or obtained as a result of criminal activity relatable to the scheduled offense. Likewise, the offense of money laundering in section 3 of the Act covers direct as well as indirect activities which lead to laundering of ill-gotten money. In the instant case, investigation clearly established that Lilian Technocap Private Limited and Sigo Technology Private Limited were involved in operating and collecting money from the investor in the name of the HPZ token and had received approximately 115 crore from gullible public in the guise of HPZ token app, and money was further transferred to various entities, individual, including Finbuck Solution Private Limited and Quickcom Information Technology Private Limited. Subsequently, part of proceeds was returned to the investors and part proceeds were further diverted to various other entities through bank accounts and accounts maintained with payment aggregators. Further analysis of bank statement of Finbuck Solution and Quickcom Private Limited revealed that huge payments are also received from various dubious entities. Huge proceeds of crime layered through these entities have been transferred to crypto exchange by Yocoin and from there to foreign private wallets. On examination of director of Biocon, it was further revealed that another suspicious entity, Jyotisha Technology Private Limited, has also transacted in cryptocurrency and laundered the proceeds of crime. Thereafter, inquiry was made from payments gateways and banks. It was gathered that Jyotisha was actively indulged in fraudulently activities and cheating gullible people. Paragraph 3. The process prescribed under the statute was duly followed. In present case, the Deputy Director has issued provisional attachment order on the reasonable belief that if property involved in money laundering is not attached immediately under Chapter 3 of the Act, the non-attachment of property is likely to frustrate proceeding under the Act. The empowerment to issue PAO is conditional to the formation of requisite reasonable belief. The reason for such belief to be recorded in writing on the basis of material in his possession, that if property involved in money laundering is not attached immediately under Chapter 3 of the Act, the non-attachment of the property is likely to frustrate proceeding under the Act. There is no dispute as to the authority of the Deputy Director to pass the provisional attachment order. While examining the compliance of Section 5, what is required to be seen in the present case is that the Deputy Director has recorded the reason to believe on the basis of materials in his possession. The involvement of the defendant company in parking and routing the ill-gotten money is well explained in Para 2 above, hence is not being reiterated. As per Section 3 of the Prevention of Money Laundering Act 2002, whoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition or use, and projecting or claiming it as untainted property, shall be guilty of offense of money laundering. For the removal of doubts, it is hereby clarified that a person shall be guilty of offense of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following process of activities connected with proceeds of crime, namely concealment, possession, acquisition, use, projecting as untainted property or claiming as untainted property in any manner whatsoever. The process of activities connected with proceed of crime is a continuing activity and continues till such time a person is directly or indirectly enjoying the proceeds of crime by its concealment or possession or acquisition or use or projecting it as untainted property or claiming it as untainted property in any manner whatsoever. Therefore, the defendant company was actively involved in commission of scheduled offence and money laundering. As established in the provisional attachment order, the defendant number 11, Jyotisha Technology, was involved into receiving money from the public by operating illegal apps, website, and part of the money so generated was siphoned abroad in crypto assets through crypto exchanges. The company could not be located at the registered address. The transaction in the accounts had no business rationale. Thus, the company was actively involved in money laundering, and balances lying in the accounts are the direct proceeds of crime generated through schedule of offence related activities. During the investigation under PMLA, the director of the company, that is defendant number 12 and 13, were summoned and they gave their statement under section 53 of the PMLA Act 2002. From their statement recorded, it is apparently clear both the director of the company are dummy, that they do not have any knowledge about the activities of the company. They have never attended the AGM of the company or visited the registered address of the company. They are namesake director of the company. They provide OTP through WhatsApp for banking transaction to one Mr. Thomas, who looks after the bank accounts and payment gateways account of the company, and also he operates the company from Argentina. It is apparently clear from the statement recorded as mentioned in the original complaint number 2150/24 that the company was used as tool to generate and launder the proceeds of crime generated through illegal activities and siphon it abroad. The Indian individuals have been used to fulfill the compliance requirement in India and execute the transaction involved in money laundering scheme. Hence, the contentions made are completely denied. The averment made by the defendant in the said para is misleading. Number 6, Mr. Hari Kishan Lal and Sachin Minas were the director of Jyotisha Technology Private Limited and getting monthly salary from the company. They were recommended by Mr. Vinit Misra to become director of the company. They used to send OTP for banking transaction and other company related document through WhatsApp and email to the person by name Thomas, who is controlling Jyotisha Technology from foreign location out of India. Hence, they knowingly assisted Jyotisha Technology Private Limited in generating proceeds of crime and money laundering through various gaming, betting, porn website and cheated the global people. Number 7, the adjudicating authority recorded reason to believe after carefully considering all the materials on record placed before him as well as submission made by the complainant. Number 8, a person not prosecuted for predicate offence can be prosecuted for the offence of money laundering under PMLA as pronounced by Division Bench of Honorable Madras High Court in the matter titled as P. Rajendran versus the Assistant Director in Criminal OP dated 14/9/22. Number 9, the offence of money laundering is a separate criminal offence. In this context, it may be appreciated that the Honorable Supreme Court of India, in the case of Vijay Madan Lal Chaudhary and others versus Union of India, a special leave petition criminal number 4634/2014 decided on 27/7/22 stated that the offence of money laundering is an independent offence regarding the process or activity connected with the proceeds of crime which had been derived or obtained as a result of criminal activity relating to or in relation to a scheduled offence. Further, the Honorable Supreme Court stated that Section 5(1) is not limited to the accused named in the criminal activity relating to a scheduled offence. It would apply to any person not necessarily being accused in the scheduled offence if he is involved in any process or activity connected with the proceeds of crime. Number 10, during the investigation under PMLA, summons dated 26/20 was issued under Section 52 of PMLA to the compliance officer, MSPA Payment Private Limited, Mr. Abhishek Butalia, Manager Legal and Compliance, MSPA Payment Private Limited appeared on 31/7/23 and gave his statement under section 53 of the PMLA. He earlier stated that he joined AU Payment Private Limited on 16/1/23 as Manager Legal and Compliance, and is also looking legal operations and affairs of PU Innovation Private Limited. He was asked to explain regarding Jyotisha Technology Private Limited having merchant number this registered with MS PU Payment Private Limited. He has stated that Jyotisha Technology Private Limited was registered on PU platform on August 1920 for availing payment aggregation service through the assisted onboarding process and declared itself to be involved in the economic digital paid voucher line of business with the subcategory of online gaming and declared annual turnover amount of was rupees 31 crore 20 lakh per annum. The statement account of this relationship is with ICICI Bank, RPC Delhi branch, Janadolana extension Delhi, having account number this entity had a settlement account previously with Axis Bank by the account number. There are other linked accounts found of the same entity with PU wide merchant number. The merchant was seen to generate business on PU payment aggregation services. Amount 411 crore 25 lakh. Starting from 19 August 22, 7 September 22, while another merchant GMB generated 13 crore 29, 1,329 crore 78 lakh 70,021 starting from 6th October 2021 to September 2022, and PU regular transaction and risk monitoring process. These are the statement of the director of the PAU. I will go to the operative part. You will see the order, that is 563, page number 563. The adjudicating authority has, after hearing both the parties, have passed an order, para 10. I have carefully considered the written reply filed by the defendant number 11, 12, 13, 29, 35, 35 to the notice to show cause under section 8(1) and written argument of defendant number 1, 2, 3, 7, 27, 20 and 31. I have also considered the rejoinder filed by the complainant to the written reply. The role of defendants with reference to property attached and its involvement in money laundering was also been brought on para 4.3 of this order. I have also heard the counsel for the complainant and defendants. I have considered all the relevant material placed on record before me. Number 11, having considered the material in OC, the written reply and rejoinder of the defendant number 11, 12, 13 and written argument of defendant number 1, 2, 3, 27, 28 and 31, and also the oral argument of the complainant and defendant, I find that the movable and immovable property provisionally attached by provisional attachment order number 1 of 23 dated 22/12/2010, that is movable and immovable property mentioned at page number 57 to 60 of PAU and at page number 9 to 13 of OC mentioned in the name of defendants are proceeds of crime in terms of section 21U of the PMLA 2002 and therefore involved in money laundering. Further, there is a failure on the part of the defendant to discharge the burden as required to be discharged under the provision of section 8 of the PMLA, and in view of the presumption under section 24 of the PMLA as herein above referred, which is not rebutted, I therefore hereby confirm the attachment of the property made under section 1 of section 5 of the PMLA. I therefore order that the said attachment shall continue during pendency of the proceeding relating to any offence under the Prevention of Money Laundering in 2002 before the special court and become final after an order of confiscation is passed under subsection 5 of section 7 of section 8 of the PMLA by the special court. PA number 1 of 23 dated 22/12 is hereby confirmed. Your Honor, once the adjudicating authority passed an order or confirmation has been given. Now the party who are not satisfied with the order, they can appeal before the tribunal under section 25.
1 minute. Make sure.
25. Or appeal to appellate tribunal. Yes, yes.
Appeal against order of adjudicating authority under section
26. 26. In this case, no appeal has been filed before the tribunal, Your Lordship. Your Lordship,
yes.
before I citing some of the leading cases as regards to all this, I have noted down. I would like to give my submission on the link with SPZ. I'll just read out to Your Lordship. It is not nowhere somewhere. During the investigation conducted in this case, it was found that the proceeds of crime collected from the global investors were laundered and invested in the cryptocurrency, which were then further sent outside the country. One such company which assisted the perpetrators of SPZ token scam was iBlock Technology Private Limited, running its platform in the name of Biocoin. The investigation revealed that the proceeds of crime in the SPZ token scam were used to purchase the cryptocurrency through Biocoin. Accordingly, the premises of the director of Biocoin were searched and his statements were also recorded. That Abhishek, I've noted under section 50. It was during the examination of the director of Biocoin that it was revealed that Jyotisha Technology was also invested in the cryptocurrency among others involved in the SPZ token scam. Accordingly, the PayU Payments Limited accounts and merchant IDs of the petitioner were also analyzed and several discrepancies were found. The statement of Sri Abhishek Butalia menaced in PayU has also revealed the suspicious nature of the transaction undertaken by Jyotisha Technology, including Chinese traffic, which is same as the modus operandi detected in the SPZ token scam. The statement of the directors of the petitioners have revealed that they were all dummy directors and the company was actually controlled by foreign nationals, which clearly show the underlying intent and design behind this company, which is laundering of the proceeds of crime collected from the global investors in the name of fraudulent pretexts like gambling, mining of cryptocurrency, etc.
Where are you reading from? That is
No, actually, I have noted down, Your Lordship. This is really, Your Lordship, now the petitioner contention was that Your Honor, I have compiled all the cases which I want to submit in support of my submission, Your Lordship. I will read only the operating part, Your
only
Lordship.
this.
Your Lordship, the first one, Your Lordship. Now, the contention of our petitioner was that, Your Lordship, the person not named as an accused in the predicate case cannot be made as an accused in the PMLA case.
Yes.
So, as regard to this,
And another the ground was that,
No, I'm coming. I have explained everything, Your Lordship.
okay.
One by one, I will come. Your Lordship, first, the offence of money laundering under PMLA is an independent offence, and a person not named as an accused in the predicate case can be made as an accused in the PMLA case. Your Lordship, number one, Vijay Madanlal Chaudhary and others versus Union of India. It is in page number, paragraph 269, page number 24.
269. Page 24.
24, paragraph 269.
Yes.
I may be allowed to read this only. From the bare language of section 3 of the 2002 Act, it is amply clear that the offence of money laundering is an independent offence. Regarding the process or activity connected with the proceeds of crime which had been derived or obtained as a result of criminal activity relating to or in relation to a schedule offence, the process or activity can be in any form, be it one of concealment, possession, acquisition, use of proceeds crime, as much as projecting it as untenanted property or claiming it to be so. Thus, involvement in any of such process or activity connected with the proceed of crime would constitute offence of money laundering. This offence otherwise has nothing to do with the criminal activity relating to a schedule offence, except the proceed of crime derived or obtained as a result of that crime. Then paragraph 295. Is page number 35. As aforesaid, in this backdrop, the Amendment Act 2 of 2013 came into being, considering the purport of the amended provision and the experience of implementing enforcement agency. Further changes become necessary to strengthen the mechanism regarding prevention of money laundering. It is not right in assuming that the attachment of property provisional under the second provision as amended has no link with the schedule offence. Inasmuch as section 5(1) envisages that such an action can be initiated only on the basis of material in possession of the authorized officer, indicative of any person being in possession of proceeds of crime. The precondition for being proceeds of crime is that the property has been derived or obtained directly or indirectly by any person as a result of criminal activity relating to a schedule offence. The sweep of section 5(1) is not limited to the accused named in the criminal activity relating to a schedule offence. It would apply to any person not necessarily being accused in the schedule offence. If he is involved in any process or activity connected with the proceeds of crime, such a person, besides facing the consequence of provisional attachment order, may end up in being named as accused in the complaint to be filed by the authorized officer concerning offence under section 3 of the Act. Your Lordship, then the case law Parvana Dibor versus enforcement, it is on page number 125. 125, paragraph 17. Page 125, paragraph 17. Now, similar observation was also made in this case also, Your Lordship. Coming back to section 3 of the PMLA, on its plain reading, an offence under section 3 can be committed after a schedule offence is committed. For example, let us take the case of a person who is unconnected with the schedule offence, knowingly assists the concealment of the proceeds of crime, or knowingly assists the use of proceeds of crime. In that case, he can be held guilty of committing an offence under section 3. To give a concrete example, the offence under section 384 to 389 of the IPC relating to extortion are schedule offence. included in paragraph 1 of the schedule to the PMLA. An accused may commit a crime of extortion covered by section 384 to 389 of IPC and extort money. Subsequently, a person unconnected with the offense of extortion, Your Lordship, kindly subsequently, a person unconnected with the offense of extortion may assist the said accused in the concealment of the proceeds of extortion. In such a case, the person who assists the accused in the schedule offense for concealing the proceeds of the crime of extortion can be guilty of the offense of money laundering. Therefore, it is not necessary that a person against whom the offense under section 3 of the PMLA is alleged must have been shown as the accused in the schedule offense. What is held in paragraph 270 of the decision of this court in the case of Vijay Madanlal Chaudhary supports of the above conclusion. The condition precedent for attaching the offense under section 3 of the PMLA are that there must be a schedule offense and that there must be proceeds of crime in relation to the schedule offense defined in clause U of section 1 of section 3 of the PMLA. Now, similar observation was also made in Director of Enforcement versus Aditya Tripathi. It's page number 137.
Sarah?
137. Para 13 Your Lordship. 13. Even otherwise, the High Court has not at all considered the nature of allegation and seriousness of the offence alleged of money laundering and the offences under the PMLA Act 2002. Looking to the nature of allegation, it can be said that the same can be said to be very serious allegation of money laundering which are required to be investigated thoroughly. Then para 16. Para 16 is on page number 138. May I read you? As observed herein above, the High Court has neither considered the rigor of section 45 of the PMLA Act 2002 nor has considered the seriousness of the offence alleged against accused for the schedule offence under the PMLA Act 2002, and the High Court has not at all considered the fact that the investigation by the Enforcement Director for the schedule offence under the PMLA Act is still going on, and therefore the impugned order passed by the High Court enlarging respective respondent on bail are unsustainable, and the matters are required to be remitted back to the High Court for a fresh decision on the bail application after taking into consideration the observation made herein above.
This is regarding
This
bail.
is bail, yes. Page number 149, Vijay Raj Surana. 149. Paragraph 32 to 44. 30. Your Lordship, it shocks the conscience of the court that in recent cases involving money laundering, a certain pattern has emerged whereby the FIR quashed through minor technical glitches or procedural irregularities, and with that as a ground they seek for quashing of ECIR also. The wording in the final summary portion of the Vijay Madanlal judgment in paragraph 467(5)(d) is used in isolation without due consideration to the judgment as a whole to wriggle away from the clutches of PMLA. The wording in Vijay Madanlal case cannot be accorded a narrow meaning by relying only in the summarization toward the end of the judgment, but the observation in various paragraphs and the findings made therein must be read in tandem to extract its true essence. At the outset, this court would clarify that we are neither attempting nor intending to rewrite the Vijay Madanlal judgment. The court is merely restraining from a pick and choose application of the principle established in Vijay Madanlal case, and rather is for the complete harmonious application of the judgment as a whole in letter and spirit. Any application of principle, even if in its literal form paves way for injustice, then the court is allowed to take a detour to expound the law in such a way which serve the cause of justice. If the principle of automatic quashment of ECI is adopted, arithmetically the very purpose and objective of PMLA is defeated. Paragraph 33, Your Lordship. The point of contention in the present petition falls within the contours of the judgment rendered by the Honorable Supreme Court in Vijay Madanlal case. The Vijay Madanlal case extensively deal with the validity of different provisions in the PMLA 2002. The observation made in the paragraph number 281 relevant to the case on hand is extract below. The next question is whether the offence under section 3 is a standalone offence. Indeed, it is dependent on the wrongful and illegal gain of property as a result of criminal activity relating to a scheduled offence. Nevertheless, it is concerning the process or activity connected with such property which constitute offence or money laundering. The property must qualify the definition of proceeds of crime under section 2(1)(u) of the 2002 Act. As observed earlier, all or whole of the crime property linked to the scheduled offence need to be regarded as proceeds of crime, but all properties qualifying the definition of proceeds of crime under section 2(1)(u) will necessarily be crime properties. Indeed, in the event of actual acquittal of the person concerned or being absolved from allegation of criminal activity relating to scheduled offence, and if it is established in the court of law that the crime property in the concerned case has been rightfully owned and possessed by him, such a property by no stretch of imagination can be termed as a crime property and ex consequent proceeds of crime within the meaning of section 2(1) as it stands today. On the other hand, in the trial in connection with the scheduled offence, the court would be obliged to direct return of such properties belonging to whom. It would be then paradoxical to still regard such property as proceeds of crime despite such adjudication by a court competent jurisdiction. It is well within the jurisdiction of the concerned court trying the scheduled offence to pronounce that matter. 34. A blanket application of the observation made in the aforementioned judgment will not advance the object set out under the PMLA 2002 and in turn will defeat its primary object. The Vijay Madanlal case is binding precedent for all courts below, and on carefully application of the judgment analyzing on a case to case basis, the output shall differ for each case and not render the same result. Every case is merited with different facts and circumstances, and the application of law should not only meet the ends of justice but should also further the objective behind the statute. The principle in Vijay Madanlal is set out the clear aspect of proceeds of crime under PMLA 2002 as under. 36. The court observation above hold that where a person is acquitted or absolved of a criminal activity relating to a scheduled offence and on establishing in a court of law that the crime property is an illegitimate ownership, such property cannot be termed as a crime property, and in consequent offences losses its significance. Hence, to warrant a quashing of ECIR, mere quashing of the FIR on technical ground by itself does not make the ECIR liable to be quashed. This is not the observation set up in the Vijay Madanlal case. Now, see, now you will see these are the cases where it clearly says that under PMLA it is an independent offence, and a person not named as an accused in the predicate case can be made as an accused in the PMLA case. In bit of section 3 of the PMLA that I have already explained, Your Lordship. I'm not repeating. Now, the most important part, Your Lordship, section 24 of the PMLA. This is 11, page 51. Page 51, small paragraph, Your Lordship. Page 51. In in Vijay Madanlal Chaudhary and other versus Union of India, is 51 burden on proof. Burden of proof, paragraph 327.
Yes.
The validity of section 24 of the 2002 Act has been SL. This section has been amended in 2013 by Act 2 of 13. Before that amendment, it read thus: burden of proof. When a person is accused of having committed the offense under section 3, the burden of proving that proceeds of crime or untainted property shall be on the accused. Your Lordship, that a stay or quashing of a criminal case can only be ordered in the rarest of rare case. In Your Lordship, in Niharika Infrastructure Private Limited versus State of Maharashtra, the Honorable Court had clearly given the guidelines that only in the rarest of the rare case the quashing can be done. It is on para 64 to 72 of Niharika Infrastructure Private Limited. Very now, Your Lordship, although I have reflected some other related case law that I have also mentioned with paragraph and the page numbers. Your Lordship, next is ECIR. ECIR that was registered by the Enforcement Director, and this is also one of the prayer of the petitioner for quashing of the ECIR. But Your Lordship, in Vijay Madanlal Chaudhary, this is a very leading case as regard to the EDK. In page number 111, paragraph 457.
111. Para?
457. Your Lordship, ECIR, unlike an FIR, is merely an internal document, and the same is not liable to be quashed or proved to or provided to the accused. Section paragraph 457. Suffice it to observe that, being a special legislation providing for a special mechanism regarding inquiry, investigation of offense of money laundering, analogy cannot be drawn from the provision of 1973 Code in regard to registration of offense of money laundering, and more so being a complaint procedure prescribed under the 2002 Act. Further, the authorities referred to in section 48 of the 2002 Act alone are competent to file such complaint. It is a different matter that the materials, evidence collected by the same authorities for the purpose of civil action of attachment of proceeds of crime and confiscation thereof may be used to prosecute the person involved in the process or activity connected with the proceeds of crime for offense of money laundering, considering the mechanism of inquiry investigation for proceeding against the property being proceeds of crime under this Act by way of civil action, attachment and confiscation. There is no need to formally register an SIR, unlike the registration of an FIR by the jurisdictional police in respect of cognizable offense under the ordinary law. There is force in the stand taken by the ED that ECIR is an internal document created by the department before initiating penal action or prosecution against the person involved with process or activity connected with proceeds of crime. Thus, ECIR is not a statutory document, nor there is any provision in 2002 Act requiring authority referred to in section 48 to record ECIR or to furnish copy thereof to the accused, unlike section 154 of the 1973 Code. The fact that such ECIR has not been recorded does not come in the way of authorities referred to in section 48 of the 2002 Act to commence inquiry investigation for initiating civil action of the attachment of property being proceed of crime by following prescribed procedure in that regard. Now, the similar observation was also observed in N. Dhanraj Kochar and others, that also I have reflected in my complaint. Your Lordship, at the stage of cognizance, the court is only required to see if any prima facie case is made out in the complaint and not as to whether the evidence is adequate for supporting conviction.
Page 267. In Dhanraj Kochar, para.
There are 9 and 10 to 14. And Your Honor, the similar observation also made in Jitendra Nath Patnaik versus ED at page 271, para 12. 271, para 12. Page number 287 here. From the prospectus of the analysis made herein before, the court is of the considered view that the act of registration of ECIR against the petitioner and the investigating inquiries said to be in progress on such basis are not amenable to judicial review by this court in exercise of its inherent power under section 482 of CRPC. Further, the present motion, which is at a stage when the investigation inquiry initiated on the basis of the ECIR registered against the petitioner has not culminated in lodging a complaint under section 44 of the PMLA Act, is premature. In view of such finding, the contention raised by the party touching upon the merit of the case are not required to be gone into. Now, on the basis of the registration of ECIR, still the investigation is going on, Your Lordship. Now, since thousand crore money was involved in this, and few hundred entities are involved, Your Lordship, initially we have filed a complaint against 299 accused. Thereafter, the subsequent complaint was filed for another around 70 accused. Thereafter, again the second subsequent complaint has been filed, and now still it is going on, Your Lordship. Your Lordship, number 22, the last one, an order of a magistrate issuing process can be quashed or set aside only on the limited grounds. Now
Para
this is
22 of.
it's 22 of, it is page number 327. 327.
Nagawa versus Virana, this one.
Yes, Your Lordship.
Para.
This is Paragraph 6, Your Lordship, this is page number 331. Applying this principle to the fact of the present case, it seems to us that the present case is not one in which the High Court should have quashed the proceeding. To begin with, the order of the magistrate dated February 11, 1975, issuing process against respondent number 1 and 2 is a very well reasoned one which takes into consideration the allegation in the complaint as also the evidence adduced in support of it. The magistrate clearly applied in mind and has analyzed the evidence into three categories. Those witnesses who have deposed as eyewitness regarding the actual occurrence and the part attributed to respondent number 1 and 2. The magistrate then refers to other witnesses who corroborated the evidence of the complainant, and thirdly, the magistrate relied on the evidence of the evidence who were admittedly signatory to the dying declaration and had clearly stated the respondent and mentioned their presence of the deceased. Your Lordship, even in the instant case, Your Lordship, this is very initial stage, Your Lordship. Cognizance was taken, prima facie was found by the special courts, and summon was issued to the accused person. Now, instead of appearing before the special court and explain, after 2 years, they have preferred for the quashing of this application.
Okay.
Yes, only one defense of the accused cannot be seen at the stage of quashing. This one, just I have highlighted the paragraph and the page number also.
This is regarding
You have got the
on which proposition?
that the defense of the accused cannot be seen at the stage of quashing. I will just reflect one or two cases. All are similar objections.
Defense of accused can be. All these on the same point.
Yes, Your Lordship. Paragraph 8, small paragraph, Your Lordship. Page number 3. It is no more res integra that exercise of power under section 482 CRPC to quash a criminal proceeding is only when allegation made in the FIR or the charge sheet constitute the ingredients of the offence alleged. Interference by the High Court under section 482 CRPC is to prevent the abuse of process of any court or otherwise to secure the ends of justice. It is settled law that the evidence produced by the accused in his defense cannot be looked into by the court except in very exceptional circumstances at the initial stage of the criminal proceeding. It is treated law that the High Court cannot embark upon the application of evidence while considering the petition filed under section 482 of CRPC for quashing criminal proceeding. It is clear from the law laid down by this court that if a prima facie case is made out disclosing the ingredients of the offence alleged against the accused, the court cannot quash a criminal proceeding. Similarly, Your Lordship, at paragraph 5, 6 of page number 5, page number 6, Your Lordship, in Kamal Shivaji Pokranekar versus State of Maharashtra 2019, paragraph 5, quashing the criminal proceeding is called for only in a case where the complaint does not disclose any offence or is frivolous, vexatious or oppressive. If the allegations set out in the complaint do not constitute the offence of which cognizance has been taken by the magistrate, it is open to the High Court to quash the same. It is not necessary that meticulous analysis of the case should be done before the trial to find out whether the case would end in conviction or acquittal. If it appears on a reading of the complaint and consideration of the allegation therein, in the light of the statement made on oath that the ingredients of the offence are disclosed, there would be no justification for the High Court to interfere. Now, in the instant case, your Honor, the bank account is under suspicious. The statement of other accused has already given that the petitioner's company was involved in purchasing the cryptocurrency. He- So the prima facie is already there. Now the merit that will be decided by the trial court, Your Lordship. 6. Defenses that may be available or fact aspect which, when established during the trial, may lead to acquittal and not grounds for passing the complaint as the threshold. That said, the only question relevant is whether the averment in the complaint spell out the ingredients of a criminal offence or not. Similarly, in Chand Dhawan versus Jawaharlal, para 8, page number 8. Page number 11, Your Lordship. Paragraph 8. In the present case, we have stated that the allegations in the complaint are specific and clear that during the subsistence on an earlier valid marriage, respondents 1 and 2 have entered into a second marriage and have thereby committed an offence falling under section 400. The complainant have found the fact on oath. The 2 witnesses produced the complaint before the magistrate have supported that case on the basis of statement on oath of the complainant and read along with the evidence of the 2 witnesses thus recorded and the material available before the magistrate to get himself satisfied that cognizance should be taken and process issued. The magistrate was satisfied that an offence had been disclosed and accordingly the summons had been issued. The High Court was persuaded to take the view that the continuance of the proceeding would be an abuse of the process of the court only on the basis of the additional material produced by the respondent. The material thus produced have not been admitted or accepted by the appellant. The truth or otherwise of the allegation in the complaint is a matter of for proof. When the materials relied on by the respondent required to be proved, no inference can be drawn on the basis of those materials to conclude that the complaint is false. The High Court was not justified in assuming that the first information report had been lost by the complainant solely because he had not filed any reply before the High Court denying the fact. It does not appear that sufficient opportunity was given to the appellant to do so. The affidavit of one of the person who is stated have performed the criminal would have been no assistance in the drawing any interference in either way. In Swan Singh versus State, page 13, paragraph 8. Page number 17, Your Lordship.
Yes.
Paragraph 8. It may be noted that the trial has still to be held and the appellant will have an opportunity Paragraph 8.
Yes.
It may be noted that the trial has still to be held and the appellants will have an opportunity of establishing their innocence in the trial. At this stage, all that the High Court can see in the petition under section 482 CRPC or in a writ petition is whether on pursuit of the FIR, treating the allegation to be correct, a criminal offence is prima facie made out or not, or whether there is any statutory bar by Indian Well Corporation and NPC State of Orissa. At this stage, the correctness or otherwise of the allegation in the FIR has not been seen by the High Court, and that will be seen at the trial. It has to be seen whether on a pursuit of the FIR a prima facie offence is made out or not.
Okay, Mr. Gupta.
Yes.
You have, these are all on the same point.
Same point, yes.
And you have given the paragraph.
Paragraph here.
I will read it to you.
Yes. Your Lordship,
What else?
once again I would like to take on my objections in my affidavit in opposition, Your Lordship. And thereafter I will conclude.
Yes.
Preliminary submission at 5B. It is respectfully submitted that the non-arrangement of the present accused in the predicate schedule offence case does not in law constitute a bar to his prosecution under the Prevention of Money Laundering Act 2002. The PMLA creates an independent, though derivative offence of money laundering under Section 3, which is person specific in its application to laundering conduct, but offence dependent only to the extent that a valid schedule offence and corresponding proceeds of crime must exist. Under Section 3 of the PMLA, the offence of money laundering is defined broadly to include any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, use, or possessing or claiming it as untainted property. Further, Section 2U defines proceeds of crime as property derived or obtained directly or indirectly as a result of criminal activity relating to a schedule offence. A plain reading of this provision reveals three essential ingredients. First, commission of schedule offence. Second, generation of proceeds of crime therefrom. And third, involvement of person in activities such as concealment, possession, acquisition, or use of such property. Notably, the statutory language does not mandate that the person accused of money laundering must also be an accused in the schedule offence, as the word who is instituted to charge with liability of money laundering is whosoever. The emphasis lies on the handling and treatment of the proceeds of crime. This nonsense has been clarified and reaffirmed through a series of judicial pronouncements. The Honorable Supreme Court in Vijay Madan Lal Chaudhary versus that I have already reflected, Your Lordship, that offence under Section 3 is independent of the schedule offence, while the existence of proceed of crime is a sine qua non. The involvement of person in laundering those proceeds constitute a distinct offence. The court emphasized that the process or activity connected with such proceed, such as concealment or projection as untainted, form the gravamen of the offence irrespective of whether the person participated in the original criminal activities. Building upon this reasoning, the Honorable Supreme Court in Pavna Devor versus Directorate of Enforcement 2023 explicitly addressed the question at hand. The court observed that it is not necessary for a person accused under Section 3 of the PMLA to have been named in the schedule offence. By way of illustration, the court explained that a person who is entirely unconnected with the commission of the predicate offence may nonetheless be guilty of money laundering if he knowingly assists in the concealment or use of the proceeds of crime. For instance, if an individual aids in disguising funds obtained through extortion, a schedule offence under the Indian Penal Code, such assistance would attract liability under the PMLA, even though the individual was not involved in the extortion itself. This interpretation underscored the expansive reach of the statute and its focus on the life cycle of the illicit funds rather than solely on their origin. A similar position was reiterated in the decision of the Honorable Allahabad High Court in Niharika Singh versus Directorate of Enforcement. The Honorable Court, relying on the principle laid down in Vijay Madan Lal Chaudhary and Pavna Devor, held that even if a person is not named in the charge sheet pertaining to the schedule offence, such omission does not preclude prosecution under the PML. The court observed that if there exists material indicating involvement in activities such as layering, concealment, or utilization of proceeds of crime, the individual can be arraigned as an accused under the PMLA. In the fact of the case, the applicant was alleged to have received and utilized proceeds of crime, including through bank transfer and acquisition or of immovable property. The court held that this allegation warranted investigation, notwithstanding the absence of her name in the predicate offence. Further, judicial support for this proposition can be found in Sudhir Gupta versus Directorate of Enforcement, where the Supreme Court observed that merely because a person has not been named in the predicate offence does not mean that he cannot be prosecuted under the PMLA. The pronouncement reinforces the principle that the offence of money laundering targets the handling of illicit proceeds and not merely the commission of the underlying. At the outset, I will not repeat, Your Lordship. Number D, the present petition is not maintainable as the case is still at trial stage before the learned Special Judge Dimapur, Nagaland, and in the matter like this where myriad of transactions are involved in the ECIR dated 12/4/22 recorded by the Directorate of Enforcement cannot be quashed at the behest of the petitioner, as the present economic offence is an outcome of pre-planned criminal conspiracy of several entities for dumping thousands of people in the pretext of investigating money for Bitcoin mining.
Okay. That's all.
Yes. Your Lordship, in the instant case, the instant case, it is not only based on the statement of the Bicon directors only. Prosecution complaint itself refers to the bank statement, merchant record, website analysis, GST analysis, and Section 50 statement of the director of the petitioner's company. Therefore, Bicon is only one link and not the entire use. So it clearly it shows there is a prima facie in the instant case, Your Lordship, and let the case be decided on merit before the special court, Your Lordship. So with all this, I rest my submission.
Okay.
I rest my submission. I am deeply obliged, Your Lordship.
No, Shiva may be permitted to make a short.
Yes.
I thought it would be very short, but anyway, I will try to be as brief as possible, Your Worship. Now, the learned counsel for the respondent, he has done a very good job, I would say, by making a very elaborate submission. And he has started his submission by referring to para 6 of the affidavit of opposition. And he has also referred to the statement made by the director. I will not take Your Lordship to those things. And the ex-director of the petitioner's company. He has also referred to the order passed by the adjudicating authority, which is passed, confirming the provisional attachment order, Your Worship. But in this petition, in my respectful submission, Your Worship, the only issue for determination by this honorable court is, and which this honorable court needs to examine, is whether in the allegation made in the prosecution complaint, which is the charge sheet, Your Worship, and also the evidence to prove the charge of money laundering against the petition company, Your Worship. And accompanying the prosecution complaint, it is part of the prosecution complaint, I have taken Your Worship to that, even if accepted in its entirety, makes out the case against the petitioner for being guilty of the offense of money laundering. Not what has been observed by the adjudicating authority or not, and Your Worship. May I take Your Lordship again to page 224. Okay, page 224. I am not placing my evidence, Your Worship, in support of my case. I am relying especially on their own documents, 224. Lordship has got it?
Yes.
224.
Yes.
Bottom in bold, para 10. This
Brief
is
summary.
brief summary of evidence to prove the involvement of the properties in money laundering, specific role of the accused in commission of the offense of money laundering. This, Your Worship, in my respectful submission, based on the material collected during investigation and also from the statement recorded, which has been recorded while examining the accused and the co-accused during investigation. Page 2 to 5. The HPG token was an app which was run by the accused person, saying such and such, in order to deceive and cheat gullible investor. It is not in itself a separate legal entity and hence not being carried as an accused. Brief about the accused person along with the roles in the commission of offense of money laundering. Everything is here. By directly as well as indirectly attempting to indulge, knowingly assisted, knowingly a party involved in concealment, possession, acquisition, use, projecting, claiming proceeds of crime as unpaid money in terms of section 3 of the Prevention of Money Laundering Act 2002 are described below. So, Your Worship, the evidence to prove the charge against the petitioner and which is part of the prosecution complaint is based on the statement materials collected and the statement of the accused and co-accused person which was recorded during investigation. Now, my submission is that, Your Worship, even if the allegation made in the prosecution complaint, that is the charge sheet, and also the evidence to prove the charge of money laundering against the petitioner, Your Worship, is accepted in its entirety, Your Worship. There is no material even to remotely suggest that the petitioner company has either collected money from gullible public on behalf of HPG token, against whom a complaint FI has been filed and which is the predicate offense, Your Worship, nor having received any proceeds of crime from the predicate offense, Your Worship. And therefore, my respectful submission was that the criminal proceeding against petitioner under section 3 of PMLA has been initiated purely based on assumption, Your Worship. And Your Worship, I don't know, BJ Madanla Chuli yesterday I have, and even the learned counsel for the respondent
Yes, it is
has.
here also.
And that case, Your Worship, para 382.8 squarely covers my case, Your Worship.
You have read it earlier also.
Yes.
Yes.
That just. 382.8, Your Lordship has got it. Page number is 306 in Vijay Madan Lal Chaudhary. 306.
306.
Your Lordship. Lordship has got it. 306 para 382.8.
Para 382.
306. Lordship has got it.
Wait.
Mine is Vijay Madan Lal Chaudhary. Or in case if my learned friend has given from SEC online, the
Yeah, this
pagination
is
will be
SEC
different.
online.
Yes, pagination will be
This is
different.
from SEC
So in
online.
SEC, I
I
am.
think you have also supplied.
Yes, Your Lordship. It's bulky, it's thick one, it's thick. Oh, we have given the list of books, Your Lordship, I'm sorry. List of
382.
Yuji Madan Malviya says. So from SCC it was para, I think.
SCC online and SCC,
You referred to para 3,
382.
382 point.
8.
It's yes.
May I read? The offense under section 3 of the 202 Act is dependent on illegal gain of property. Illegal gain of property, your lordship may kindly consider as proceeds of crime as a result of criminal activity, which is the offense alleged to have been committed by HPG token relating to a scheduled offense. And the case of the petitioners is that there is nothing, no material to establish either whether I have received any money on behalf of SPG token, nor have I received any process of crime from HPG token. There is nothing in the prosecution complaint. That is my case. Next, your lordship. Second part, for the same paragraph, fourth line. The authorities under the 202 Act cannot prosecute any person, lordship has got it, cannot prosecute any person on notional basis or on the assumption, there is my case, that a scheduled offense has been committed unless it is so registered with the jurisdictional police and or pending inquiry trial, including by way of criminal complaint before the competent forum. And in this connection, your lordship, the other day, I have placed before your lordship the judgment order passed by the Honorable High Court of Madras in RTM, Power Private Limited, your lordship, where section 66.2 was elaborately discussed and dealt with, your lordship. Now, the learned counsel for the respondent, your lordship, has placed before your lordship a letter from the respondent
to the
addressed to SP.
investigating.
From the letter, it is clear that they have only given the status, the progress of the inquiry in connection with the critical offense.
Yes.
It is not a complaint against the petitioner's company for if their involvement in betting, gaming, or other website information. And this is not what is contemplated by section 66.2 of the PMLA, your lordship. This is just a status report of the inquiry, investigation. And what the Honorable Supreme Court has said in Para 3.2.8 is that a complaint has to be filed before the jurisdictional police. This is not a complaint before jurisdictional police. Okay. So this letter does not support the case of the respondent. The learned counsel for the respondent has also has taken the lordship to section 26 of the Act,
Yes.
which provides for appeal
Appeal.
against the order passed by adjudicating order. Your lordship. I hope the lordship has got the judgment passed by the division bench of the Honorable High Court in Madras, IKM Power Private Limited, 2025. Lordship.
Yesterday I found Lordship has got it. RKM, Power Gen Private Limited.
RKM, yes,
Lordship.
yes.
Lordship may, the first page, Lord in bold, prayer in writ petition 4297, your Lordship has got it? In bold. First
Prayer
page.
in WP 4297,
497.
yes.
Now, this is for quashing an order under section 17(1)(a). Section 17(1)(a), your Lordship, it provides for freezing of fixed deposit, Lordship. And here, and so far as property is concerned, attachment of property, your Lordship, for property, section 5 applies, Lordship. In other words, when it comes to freezing of bank, this thing, section 17(a), and when it comes to attachment of property,
Property,
section
section 5.
para 63. So this writ petition for quashing of the freezing of fixed deposit, para 63, your Lordship has got it. This was allowed with cost.
Unless and until proceeds of
Third line from the bottom. Writ petition 4297 of 20 is allowed with cost. So in my respectful submission, your Lordship, section 26 of PMLA is not a bar for this court to exercise if prosecution complaint is quashed and set aside. The rest are all consequential, your Lordship. Now, the learned counsel for the respondent also taken your Lordship to a case law where it is held that ECR cannot be
yes, yes.
Now, that was a case where the prayer was to quash, if I'm not mistaken, your Lordship, subject to correction, the prayer was to quash the ECR before filing of prohibition complaint under section 44. And this is a case where step prosecution complaint has been filed under section 44. I've taken your Lordship to that, your Lordship. Now, if prosecution complaint is quashed into court, ECR becomes consequential, your Lordship. And this is a case where your Lordship, 2023-5 High Court, this is by Honorable High Court of Delhi, your Lordship. I have the case law I am giving. I'll just take your Lordship to last page, last para 36, last line. To cut short, your Lordship. ECR stands first. Lordship has got it. Para 36.
Perhaps initiate or continue to serve investigation in connection.
And even otherwise, your Lordship, if prosecution complaint is included with your Lordship, then the ECR becomes consequential, your Lordship. Now, the learned counsel for the respondent has also taken your Lordship to the issues of summon when it is to be interfered with, your Lordship. May I take your Lordship to page 36, the summon. Page 36, part 1. Lordship has got it?
Yes.
May I read on? Present such and such, heard such and such, a complaint under such and such is received along with report and informed charge sheet from in form of charge sheet. There is a prosecution complaint for the offence made under such and such against such and such. From a perusal of the charge sheet, that is a prosecution complaint, and the accompanying material present report, there being a primary case cognizance, is taken for offence of money and case report is taken by file. Register this, issue summon to all the 299 accused persons. Why I'm praying for quashing, your Lordship? Yes, yes, for your motion. This is 2021 5 SCC 435. Para 18. This is what has been quoted from Pepsi Foods, Your Worship. Para 18. That in italic, I'll read out, Your Worship. In italic, someone, the extract from Pepsi Food. Worship has got it?
Yes.
Just italic, I'll read out. 20. Summoning of an accused in a criminal case is a serious matter. Criminal law cannot be set into motion as a matter of force. Now, in italic, the order of the magistrate summoning the accused must reflect that he has applied his mind to the facts of the case and the law applicable thereto. Now, in my respectful submission, Your Lordship, in the end, as I have said, Your Lordship, even if the allegation made in the prosecution complaint in the prosecution complaint, the allegation made, and also from the evidence which accompanying the prosecution complaint, Your Lordship, even if it is accepted in its entirety, there is no material even to remotely suggest whether the petitioner having collected any money on behalf of SPG token, nor is there any material to show that petitioner company having received any proceeds of from HPG token. Right? Now, but without recording any satisfaction, Your Lordship, in my respectful submission, the learned special judge, PMLA has issued the same. So, I am relying on the judgment, the law laid down by the Honorable Appeals Court as per this, Your Lordship. Even if the summons is not legally sustainable and is liable to be interfered with, Your Lordship. Therefore, my respectful submission, Your Lordship, under the given facts and circumstances, initiating criminal proceeding against the petitioner under PMLA amounts to clear abuse of the process of law, and therefore, the proceeding in respect of the petitioner in connection with ML case number 1 of 2024, Your Lordship, which is pending before the special court PMLA Dimapur, is liable to be quashed in the interest and in order to prevent the abuse of the process of law, Your Lordship. In fact, permitting the respondent to initiate proceeding against me and to face trial amounts to clear abuse of the process of law. That is all. Much obliged.
Yes. Heard Learned Counsel for the petitioner, Mr. T.B. Jammeh. Also heard Mr. Y.P. Gupta, Special Public Prosecutor for the Enforcement Directorate. Hearing is concluded. Order reserved. Motion. Yes.
For admission, item number 1.
Yes.
Mr. Ladyship, I am representing respondent number 1 And respondent number 3,
1 and 3.
1 and 3. That is former director and present director of the higher education. Your leadership, this relates to regularization of an employee who has been now retired in the establishment of Fazali College, Mokyo. He was a night cricketer. He was been retired out now, but then this honorable court has directed us to regularize his service. So now, after doing all the formalities, we have sent the name of the petitioner to the BNI on 30th May 2026. Leadership, please appreciate this.
You give them a copy also?
Yes. May I read your leadership? Or
Yes.
Governor of Nagaland Department, Governor of Nagaland Higher and Technical Education Department, Nagaland, Kohima. To the Commissioner and Secretary, Personnel and Administrative Reforms Department, Nagaland, Kohima. Subject, requesting for verification of work track and casual employees under higher education who retired before sitting of the committee, that is 26 May 2026. Regarding, sir, in inviting reference to the Annexure A, Clause 1 of your letter, so-and-so, dated 8 May 2026, and on the subject cited above, the undersigned is directed to request you to conduct verification of work track and casual employees under higher education retired before sitting of the committee, that is 26 May 2026, in view of the fact that this department is in receipt of judgments of the Honorable High Court, White case number WBC so-and-so, 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 pertaining to Sri Sentiman All Lab Assistant, retired SCPE Kohima on 31/7/2004, Sri Chubaya Bangnai Chugidar, retired at Fazali College, Mokchung on 31/5/2022, and Sri Sajin Sach, respectively. We and the state respondents have directed to regularize their services, which at this point of time could not be complied due to lack of district level verification committee report. And it is to further apprise that several petitions have been initiated. Proceedings. Several petitioners have initiated proceedings against the government citing non-compliance of court orders. Kindly, this treat later very urgently and with utmost priority. This for your kind information and necessary action.
Yes. What happened after that?
Now, it is most probably with the banner. Your leadership is well aware. Now, this regularization used to compile all the departments, and one code used to send it to the cabinet for approval. So, I pray, allow me 3 months' time, so that everything. At that time, I'm very hopeful that it will be done. Because
No, but the writ petition was disposed in 2022. No, 22. And then why the department is moving to the PNR only in 2026?
Because the name of the petitioner was missed out.
Missed out.
Yes, missed out when the verification was done.
Otherwise, the direction of the court is only to comply with your own OM.
Correct.
Your own OM, which
Correct.
says that those who have completed 30 years will have to be regularized.
Correct. But unfortunate that the name of the petitioner was missed out when the DLB was conducted. So the problem is that
Yes.
petitioner is out of the service now. So
Yes, Lordship, it's already 2 months that they have taken time, Lordship. It's per the previous order, so they have stated that within 2 months they will consider the regularization of the petition.
Because this was sent in May. We are now in July.
we are now in June.
Nearly end of July.
Yes.
We will give you 2 months' time. Within that, you complete Learned Counsel, Ms. Kim Penyu is present for the petitioners. The Learned Counsel, Mr. Mo Inchin, appearing for respondent number 1 and 3, submits that the Department of Higher and Technical Education, Nagaland, has forwarded the name of the petitioner for regularization via letter dated 23rd May 2026, and the same is awaited. Stop. It is also submitted that the name of the petitioner had been missed out during the previous district level verification, and therefore his case had to be taken up again separately. Is it taken up again separately? Stop. It is also submitted that the PNAR department takes up the cases of regularization of such persons in batches, and therefore the regularization of the petitioner is also under process along with other similarly situated persons. So, Learned Counsel has prayed for 3 months' time in order to complete the regularization process. So, Learned Counsel for the petitioner has objected to the said prayer as on
16, Lordship.
16/6/2026. Also, this court had no, on 16/6/2026. Also, the respondents had made a similar prayer and had taken time for 4 weeks. However, they have not complied with the direction of this court even after expiry of the 4 weeks. Stop. Para. Considering the prayer of the petitioner and also the objection of the petitioner and also the prayer made by the respondents, this court is of the view that 2 months' time is a reasonable period for processing the regularization of the petitioners. So accordingly, it lists the matter of the 60 days, and on the next date fix the respondents shall apprise this court, no, shall produce the order of compliance before this court. Okay, list after 60 days, 2 months. Yes.
Much appreciated.
May I please, my Lord?
Yes, yes.
Lordship, with sincere apology, I may be allowed to make a mention for item 20.
You forgot.
Your Lordship, I was in Code 1. When I came, the apartheid started, my Lord.
Yes.
Lordship, in this matter, I may represent
Item?
20, my Lord.
20.
Yes, ma'am.
Yes.
I am representing respondent number 4 and 7. Lordship, I have filed the latest development that have taken, that has been the steps that have been taken by the respondent on 25/6/2026, Your Lordship. This affidavit, I have filed it in the form of an affidavit, Your Lordship. Now here, my Lord, the PNR as well as the Finance Department has already given their concurrence. Now it will be placed before the MRC and then the Cabinet, Your Lordship. Those are the only 2 steps left, Your Lordship. So if some time can be granted so that
This is for what? Regularization?
this is for regularization, my Lord.
Sometime, meaning?
In the sense, Your Lordship, if around 2 months' time can be granted, my Lord.
2 months.
Yes, because we don't have any authority over the MRC, neither over the Cabinet, Your Lordship, to have a sitting for this.
Yes.
The petitioner.
Learned counsel for the petitioner, Sakmu Chang is present. Stop. Learned the senior government advocate, Mr. N. Angami, appearing for the respondent number 4 and 7, submits that he has already filed an affidavit regarding the steps taken by the respondents with regard to the regularization of the petitioner service. So, learned counsel further submits that the approval of the PNAR as well as the finance
Yes.
has already been obtained, and the matter is now before the
Will be placed before the MRC.
MRC is
Manpower
Rationalization Committee,
Correct.
and thereafter before the cabinet. So he therefore prays that the matter is already under process, and that the respondents may be given another 2 months' time in order to produce the compliance order before this court. So, in view of the steps taken by the respondents, the prayers allowed least after 2 months. Yes.
I'm deeply obliged, Your Lordship. Lordship, I have, allow me to make a mention for item 25 as well, Your Lordship. Here, Your Lordship, I am representing the respondent number 1. And there are, Your Lordship, as many as 8 respondents, my Lord. And the direction is specifically to the department, which I'm not representing, my Lord.
And the other respondents are not represented.
Yes, my Lord.
Service complete.
Lordship, PNR and respondent number 8 is here to take appearance. Respondent number 2 and 8.
No, but notices are complete.
Yes, Lordship.
Learned counsel for the petitioner, Ms. Such and Such, present. Stop. The learned senior government advocate, Mr. N. Angami, appearing for respondent, submits that he is appearing only for respondent number 1, whereas there are as many as 8 respondents
yes,
in the instant petition. Stop. It is seen that the other respondents are not represented till date. Stop. List after 3 weeks in order to list after 3 weeks awaiting the appearance of the respondents number
2 to 7, madam.
7. Yes. Yes.
I'm deeply obliged, my Lord.
May I please, Your Lordship? Lordship, kindly allow me to mention item number 12, 14, 15, 16, 17, and 19, Lordship. These are all analogous, Lordship.
12,
12, 14, 15, 16, 17, and 19.
19.
Yes, Lordship, these are all analogous, Lordship. Lordship, here I'm yet to file my counter affidavit, so Lordship. Kindly grant me 2 weeks' time, Lordship.
Your
2
Lordship,
weeks.
I pray
Yes.
that all this matter will be taken together for the next.
Yes. Same order, okay. Learned counsel for the petitioner, Miss such and such, present. Stop. Learned counsel, Mr. Nisuka Chishi, appearing for respondent number.
Sole respondent, Lordship.
Sole respondent prays that he may be given another 2 weeks' time to receive instructions and to file the affidavit on behalf of the respondent. So, prayer is allowed. List after 2 weeks. So, the COP 19 20, 21, 22, 23, and 24 of 2006 may be clubbed together and listed and listed on the same date, i.e. after 2 weeks. Yes.
Obliged, Lordship.
Please, Your Lordship.
Yes.
Your Lordship, may I be pleased to mention item number 23. Your Lordship, on behalf of V. Jumomi, Your Lordship, I'm informed that he is here to receive CD in this regard. So,
This year?
Your Lordship, so after 2 weeks, Your Lordship.
Yes.
Item 23.
2 weeks.
Yes, 2 weeks.
2 weeks. Where is this from? Case is from where?
Your Lordship, I'm unaware because Your Lordship, this matter is taken up by V. Jumomi, Your Lordship.
No. Where is the case from?
Kifiri.
Ifri.
Lordship, on the last occasion, we have already asked for the city. So, Your Honor, 1 week.
1 week, because even if it's not the hard copy, he can always get the scanned soft copy, no?
Your Lordship, I'll inform the concerned counsel.
Learned counsel for the petitioner, Mr. Toshi Tamjin, is present. So, learned PP Ms. Livika submits that Mr. V. Momi is appearing in this matter and he is yet to receive a copy of the case diary. So, list the matter after 1 week. So, on the next date, the learned public prosecutor shall produce a scanned copy of the case diary. Yes.
Your Lordship, similar prayer for item 18 also. He's yet to receive a CD on behalf of Vijimon.
18.
18.
No, 18 is a criminal petition.
Yes, Your Lordship. It seems that he is yet to receive CD. No, Your Lordship. That is what.
Who's appearing in 18? Yes. Court had called for the CD in this case.
It's for Zima petition, Your Lordship.
Oh, Zima. Okay. Learned counsel for the petitioner, Ms. Shisa Jamir, is present. So, the learned public prosecutor, Ms. Livika, submits that the CD, updated CD is not received and therefore prays for some more time. So, this also list after 1 week, on which date the learned public prosecutor shall obtain the updated case diary. This is Kohima case. Okay. Yes.
Your Lordship, similar prayer for item 2, 3, and 4, and 5. Let the matter be next week, Your Lordship, on behalf of Vijimon. 2, 3, 4, 5.
Who is appearing?
In fact, Your Lordship, respondent number 1 has not filed anything yet, Your Lordship.
Does not find?
Anything. Affidavit, Your Lordship. And 2 is, state is only a performer respondent.
But the other side is also not there. The respondent is also not there. Learned counsel Ms. Esther is present for the petitioner. On the prayer of the learned PP Ms. Livika on behalf of Vijimomi, list the matter after?
Next week, Your Lordship.
List the matter after a week. Yes.
Your Lordship, similar prayer for 7 also, on behalf of Vijimon.
7 also?
Next week.
After a week.
Next week.
Next week. But
regarding this now, in this,
yes.
I pray that the
Item 7.
I pray that the matter
Time for item number 7. For the petitioner.
For 7. In item 7.
7 last week, yeah.
No, in this government is also a party.
yes,
Item 7.
Okay.
I'm putting respondent
Okay. When do you want?
next Thursday,
Next Thursday. Okay.
with or without the CD.
Lordship, can the matter be taken up after?
Yes?
Can the matter be taken up after 3 weeks, Your Lordship?
After 3 weeks. Why?
I have some difficulty. The English Council has been struck in the blood in the upper side.
7.
Learned counsel for the petitioner, Mr. S. Gautam is present. Stop. Learned counsel Ms. Livika is present on behalf of Mr. V. Jimomi, Learned PP. Stop. Mr. L. Ralu is present for respondent number 3. Learned counsel for the petitioner has prayed for listing the matter after 3 weeks. Stop. You have objection to that.
Yes.
However,
In fact, for over 7 or 8 months, the petitioner's counsel or the petitioner has not even pursued the matter. Only on the last occasion, at the instance of this court, as once notice was issued, the petitioner counsel appeared on the last day. At his instance to deal with the matter was his. Unfortunately, the CD has not been has not even come, but already more than 1 year is left. And on the materials available in the record, I believe the matter also can be disposed of. We are
What is
challenged-
the difficulty in producing the CD?
It's a Dimapur piece. Dimapur.
Lordship, my apologies, I am not able to hear you, Lordship.
Cannot understand anything. So, Learned, the PP Miss Livika has prayed for listing the matter after 1 week as Mr. V. Jimomi is yet to obtain the case diary. Stop. At this submission, the Learned Counsel for the respondent number 3 prays that the matter needs to be disposed of urgently as it has been pending for the past 1 year, and in fact today it has been fixed at the instance of
Yes, instance of the
the instance of the petitioner. So, accordingly, list the matter after 2 weeks. Okay,
Lordship, the date may be fixed, Your Lordship.
after 2 weeks, yes. On this 20, so 1, 2, August 6th August.
Sorry.
On 6th August, on which date the PP shall produce the scanned copy of the case diary. Yes.
Right, Your Lordship.
Please, Lordship. Lordship, I beg to mention hearing item number 28. Lordship.
Yes.
The senior counsel has some personal difficulties, so I pray that this matter will come up after 3 weeks, Lordship.
Where is that? '28.
Yes.
You mean 28?
Yes.
Okay. Learned Counsel Mr. Z. Kurno submits that the leading counsel has some difficulties today and accordingly prays for listing the matter when?
After 3 weeks.
After 3 weeks. So, Learned Counsel Mr. Intiwapang is present for the claimant respondent, and has no objections. List the matter after 3 weeks as prayed for. Yes.
Much more.
May it please your Lordship, I would like to mention item number 31 and 32 from the orders list.
31 and 32. Yes.
Lordship, let this matter be come up on Thursday,
Thursday.
on
List
23rd.
on Thursday. That will be 23rd. Third is as prayed for.
Highly obliged.
Yes, by the Learned Counsel for the petition.
For motions from the supplementary cost list, item number 33.
Yes.
Paper pop is bulky, but the issue involved is very short, Lordship. But while deciding the temporary injunction order, the Learned Trial Court has entered into the merits of the case also. That's how we were compelled to enclose the plaint as
The
well as all the
entire plaint.
pleadings. Otherwise, if we don't enclose, then stage may come that where is that statement and all these things. That's why it has been enclosed. While passing the interim temporary injunction order, it appears that the Learned Trial Court has passed the order without properly marshalling the facts, because there has been a series of litigation during the last five years. All along I was involved. I was there from the day one. I'm at least somehow conversant now what are the different stages of litigation. But it appears that the Learned Trial Court was not very clear with regard to the possession of the property as on 16/9/2021. That is the date when the first writ petition was disposed of by this Honorable Court. And that day, a direction was passed by this Honorable Court to maintain status quo. So, on that day, the Learned Trial Court thought that we were not in possession. That is how, basing on the order passed in the review, the Learned Trial Court has passed the order that we are, well, in defense of the order dated 24/2/2023, we are occupying the suit property. That is how the Learned Trial Court has arrived to the conclusion, which is contrary to the record, which is contrary to the actual ground, the actual fact, Lordship. So I may be allowed to cite the little background, because without marshalling the facts of the case, The learned trial court has passed the order. I don't want this honorable court to commit the same mistake also. So, as far as possible, I will just narrate in the nutshell. This is a dispute with regard to the Okataon Baptist Church and the 3 independent churches, which are the offshoots of the Okataon Baptist Church. Like that, we have in Kohima about 7 different fellowships, but then it is not separated yet. But Lordship will remember that in Mokokchong, Alambang Baptist Church, Singkuman Baptist Church, Kamlong Baptist Churches, they were all under the Mokokchong Town Baptist Church, and then subsequently in due course they were granted independent status. So also in Dimapur, Lordship will recall that the Indecent, Seoul, Sawimkam, all this, and then Patambukri, they were all granted independent churches, and there is no problem with regard to the issue of property and all that. But then here, what happened? Oka Town Baptist Church was established in 1990. It was established, that time, it was a small church, and the town was also small. But in due course, the town has been developed, so the population, the believers also increased, which compels the church to establish sector fellowship churches. So these are called fellowship, sector fellowship churches, as is normally done in any other parts of the state. Now, since it has become inconvenient, in due course, believers have increased, it is very difficult to come under one umbrella. So from 2016 to 2018, 3 fellowships, they have applied to the mother church for having a separate independent church. That was discussed in the annual general meeting of the Okataon Baptist Church, the main church, with the representation of all the believers. And then it was decided, as many as 4 or 5 decisions were taken to allow separate independent churches. But then a condition was laid. Now that we are celebrating centenary in the year 2019, that was celebrated on 29 and 30th November 2019. And then after celebration of that centenary, we can do that. That was the decision, and it is on record. Now what happened? Lordship may remember, that was a time when COVID-19 has struck the entire world. So it was moveless, motionless, so it was very difficult to implement immediately after the centenary celebration. And then again, it got delayed. So the believers of 3 churches become little impatient that, look, we have taken a decision unanimously to allow up to the centenary, but then centenary is over, COVID is also going to be over, allow us to go independently. But then nothing was done. Ultimately, they have approached the executive secretary, LBCA, that is Luther Baptist Churches Association, who is the apex body under which all the churches are there. Now, on 9/2/2021, we started independent churches, believing in the independent churches. We have taken possession of the property on 9/2/2021.
9/2/2021.
That is we have taken over the possession. I will show from the readings after some time. Now, among the 3 fellowship, again, there were few believers who still wants to go to the main church, mother church, we call it mother church, main church. So dispute arose. Majority are in the independent, but some believers wants to go to mother church. So there was some sort of a law and order problem. So the deputy commissioner thought it appropriate to call all the social organizations, Luther Huhu, Luther Iloi, that women organization, and then the Luther Students Union, all ward chairmen, and then a meeting was held on 12/2/2021, and it was decided that in the 3 fellowship, there should be 2 church timings to worship. The main group, 1 timing, and the others, because we cannot deny any believers, so the other 1 timing, 1 shift. So 2 shifts were fixed by the deputy commissioner. Agreed by this order, the Okatown Baptist Church, they filed a writ petition before this honorable court. That is WBC number 69K of 2021. Now what happened? While filing the writ petition, it was filed basing on two grounds. Number one, it is violative of Article 25 of the Constitution because we are not freely allowed to worship, number one. Number two, the order was passed by the Deputy Commissioner without hearing us. That is Okatown Baptist Church. Now, we got the notice, the three churches got the notice. So we responded to the case. We said, look.
The two timings for worship was for the main church.
No, three independent
for the
churches.
three churches.
Yes.
Oh,
And then the chokitors were directed to hold the keys of the churches and the other. Now what happened? We filed the counter affidavit in opposition contending that, look, by fixing two timings by the Deputy Commissioner, what fundamental rights of yours have been violated when everybody has been allowed to worship. Only order is with regard to fixing up two timings. So you are allowed to worship. Therefore, there is no violation of fundamental right, number one. The second ground, that the order was passed without hearing them, that is Okatown congregation. In that case, Luther Hoho is invited, Eloi is invited, Luther Students Union is invited, all our chairmen are invited. With the consent of all these deliberations, order was passed by the DC. So we have taken a stand that, look, Deputy Commissioner is not supposed to furnish and serve the coffee to your bedroom. So all the stakeholders were invited and the order was passed by the DC. There is nothing wrong. That was our contention. But before we entered the case, the interim order was already passed, suspending the DC's order. Fine. Against the interim order, we filed an IA for vacation, but then better to hear the entire case. So we agreed, we proceeded. Now what happened? On 14th of August 2021, 14 August 2021, the LBCA, Luther Baptist Churches Association, LBCA in short, they have passed an order recognizing the three churches as independent churches. And to that effect, a formal certificate was issued on 29 August 2021. Therefore, since they were recognized as independent churches, but the writ petition was pending that time. So ultimately, writ petition came to be heard on 16/9/2021. That date will be very important because this has a reference to the order passed by the trial court. 16/9/2021, and whose possession? 2021. And this date, the property was in whose possession, because that will be important. So on this date, matter was heard by this honorable court. My Lord Justice Sudu was there. And I have pointed out about the subsequent development. The other side was represented by Mr. N.K. Loikam. So I have submitted that during the pendency of the writ petition, three independent churches have been granted independent status by the LBCA. Therefore, the issue is with regard to the worshipping in the three churches. So it is more or less resolved. So virtually there is nothing left to be considered in this writ petition. That was my submission. But in response to, and then the Honorable Court acts inquired from the, it is there on the record, in the order itself. I will refer later on. Honorable Court inquired from the counsel for the respondent. Is it correct that they were recognized as independent church? Yes. They were granted independent status, but they might come and disturb us during the worship. That is Okatown, because he was representing Okatown. So I said, no, there is no question of going to the main church. We want to be independent, so we are worshiping independently. We were recognized as independent churches. Therefore, there is no point going there and disturbing them. So we are not going there anymore. We have our own church to worship. That word has a bearing. How can you say that when all the properties are registered in the name of Okatown Baptist Church? How can you say that That will come later on, but just it will be relevant. You can say that we have our own church. But Lordship will be aware. As I said, we were one. Everything was developed by all of us jointly, like any other churches in the state. Okaton Baptist Church also, we were there. We were all together, and 3 churches were under Okaton Baptist Church. That is an arithmetic position. But learners, the trial court thought that we are a breakaway corp under some rebel corp, as if we were from some other place. We came from Bangladesh and then trying to grab somebody's land. No. But the order, if we go carefully, the learned trial court went in that line. Now, properties, everything is registered in the name of Okaton Baptist Church. We have admitted that fact. Yes, we were together. When we were together, it was purchased. So obviously, it will be in the name of Okaton Baptist Church. But subsequent development, we were recognized as independent churches. So whatever we are worshiping, let it be remain. That was the issue. Now, after the 3 churches were granted independent status, that was the direction.
No, but how was WPC 69 disposed of?
WPC 69 was disposed of in the light of that, what I have been submitting in that line, it was disposed of, there is nothing left. But at that relevant point of time, the keys of the churches were with the Deputy Commissioner. So we have made a prayer that released the keys of the churches. So basing on the order passed by this Honorable Court on 16/9/2021, Deputy Commissioner have released the keys of the churches. And it was given to us, the keys of the churches and other apartments. After 2 days, on 18/9/2021, the council for the Okaton Baptist Church submitted the application to the, who is also a lawyer, submitted an application to the Deputy Commissioner to the effect that, look, the order passed by the Honorable High Court do not include the keys of the apartments and Sunday school keys and pastor's residence. The order of the Honorable Court only says about keys of the churches. Therefore, except the keys of the churches, other keys should be retrieved. That was the prayer made to the DC. In response to that complaint, DC wanted to retrieve all the other keys. But on the first day, when we have furnished the order passed by this Honorable Court, pursuant to the order passed by this Honorable Court on 16/9/2021, DC has released the entire key, pursuant to the court order. But then subsequently it was tried to be interpreted. So, you wanted to retrieve the keys. That was a time when there was going to be a serious law and order problem. DC has requisitioned the police forces from Kohima, Dimapur, and as many as 15 vehicles were sent, deputed, to retrieve the keys of the churches. But then, and that was the day when a review petition was moved before this Honorable Court. Because we wanted to be clear, we cannot take law into our own hands, we cannot defy the law. Therefore, the only way to clarify whether the keys of the churches will include the keys of the apartment, pastor's keys, or residence quarter, or the Sunday school keys, all this. So we came. This Honorable Court passed an order that keys of the churches means all the keys. That was the order.
In the review.
But, yes, on the first day. But DC declined to release the keys. DC declined to withdraw the forces on the ground that unless I see the order passed by the Honorable Court, I cannot withdraw. There was going to be a serious law and order problem that time. Both the parties were ready like that. But then around 4 o'clock, when Mr. Muaimchen was the counsel for the state, he communicated the order through because Lordship is well aware, the order passed by the Honorable Court, after raising the court only, Lordship has to sign the order So after signing, with great difficulty, somehow he managed to get the order and then transmitted. He has transmitted. So only after that, again, he has withdrawn. The law and order has been subsided. Thereafter, it continued like that. But then, while disposing of the review application, finally, the Honorable Court has made an observation that this is not the right forum to adjudicate about the property. Aggrieved party may file a suit before the appropriate forum. That liberty was given to the parties. And it so happened that the aggrieved party turns to be Okadon Baptist Church, who is the present respondent. So, they filed a suit in 2023 because the review application 3 of 2021 was disposed of on 24 to 2023.
24 to 2023. Review petition 3 of
2021.
2021.
It was disposed of on 24 to 2021.
2021.
Yes. Yes. This, no,
No, 2023.
2023. This has reference in the order of the trial court lordship. That's why it will be important. Because in defense of this order, as if we are occupying the property, suit property. That was the conclusion the trial court has arrived. That's why that order date will be very important. That is passed in the review. That is the final order. That is 24 to 2023. And then along with the suit, they have filed a suit, that is civil suit number 1 of 2023. Along with that suit, they have filed an application under order 39 roll 1 and 2. And that is registered as civil miss case number 4 of 2023. Civil miss case 4 of 2023. And then there were proceedings. During this time, since they are claiming all the properties as if it is their own, the three churches also responded, look, all the properties were developed by all of us 20, town church as well as the three independent churches. They are involved in the three churches property, and we are also involved in the town church properties. But it cannot be taken as exclusive property of Okatan Baptist Church. Naturally, all the fellowships are developed by all of us, all the believers. So we file a counterclaim. Along with that, also we have filed an application under Order 39, Roll 1 and 2. But we have filed only last year. But they have filed the IA for perpetual injunction and temporary injunction in 2023. This application of CMC 4 of 2023 came to be heard on 1st of July 2026, after more than 3 years. After more than 3 years it was heard, it is temporary injunction. The name itself is temporary. And during all these years, we were peacefully worshipping in our respective independent churches because status quo order was passed by this Honorable Court. Now, the learned trial court arrived to the conclusion. The court even entered into the merits of the case, whether there is a prima facie case or not and all that. And since all the properties are registered under the name of Okadam Baptist Church, an assumption was drawn that, we are claiming the property without any right. That is one point. Whereas all the properties were raised. And in the order itself, it is mentioned that 3 churches were developed with the contribution of the members of three fellowship. But our contention was, look, not only these 3, including Dow Church, all of us, and you are also there. It's not that they are claiming exclusively or we are claiming exclusively, but the learned trial court was of the view that entire thing is belonging to, developed by only Okadon Baptist Church, and whatever contribution we have made, more than 23 crores, are voluntarily given. Therefore, no case has been made. Now,
Understood.
I would
Let's
like
see
to,
them in pure order.
Indian order, kindly come to page 648 in the volume 2. I will take your lordship only to the relevant portion. Kindly come to page 648 is the Indian order. It starts from there, annexure M, page 648. And I would like to take your lordship to page 667. Top. 667. For easy convenience, if lordship can mark with a pencil about the state of the orders, it will be convenient for your lordship also. From the, I will read only the top which is relevant. From the above, it is made abundantly clear that as on 16/9/2021, the suit properties are in possession of the applicant plaintiffs, that is the Okadon Baptist Church. Hence, current possession of the suit properties by the parties, defendants, number one, so and so, so and so, is in defiance of the judgment and order dated 24/2/2023, passed in review petition number 3 of 2021. Therefore, it has become relevant what these two orders says also, on what basis the district judge arrived to the conclusion that the plaintiffs were in possession on 16/9/2021. Because I was mentioning that that date will be relevant. 16/9/2021 is at page 100, and more particularly, when there was no pleading in the application in the IA that the properties are in danger also, and there is nothing of that sort in the pleading. Which court order we have defined? That is to be seen from the order itself. What order was violated? If so, how it was violated? That will be relevant. So, and also see page 669. There is an order 669,
100 is?
Roman 2. 100 is in the volume 1. That is the order passed in the writ petition. First, I think better to finish up this first. This is only 3 pages, so it will be relevant to read.
WPC 69 of 2021. This was disposed of on
16/9/2021. Let me read 101 from the third paragraph, because others are party about the appearance of the parties. 101. Okadon Baptist Church, which is the mother church of all Baptist churches in the Okadon, in course of time has increased in the number of its members. Therefore, the 3 respondents who initially came into existence as fellowship under its board wanted to have their own independent entity for the better management and growth. Therefore, the mother church, in a meeting held on 30/12/2016, decided to release them as independent churches after having a meeting and after celebration of 100 years anniversary. Thereafter, in a meeting held on 25/3/2017, the Okadon Baptist Churches Deacon Board decided to release them after celebration of 100 years on 28 and 29 December 2019. The resolution, decision, and Deacon Board stated above was approved by the General Body of the Mother Church on 25/3/2017. However, releasing of the 3 churches as independent church did not happen even after the celebration of 100 years anniversary. Therefore, the respondents approached the Lota Baptist Churches Association for their intervention. In the process, some misunderstanding between the parties happened, and the writ petitioners approached the Deputy Commissioner Oka for intervention. After hearing the parties, the Deputy Commissioner passed an order dated 12/2/2021, wherein certain arrangements were made for conducting worship in the Mother Church. The same was purportedly made to facilitate worship for all the parties at different times. But being aggrieved by the arrangements so made by the Deputy Commissioner, the petitioners came before the court by filing the instant petition challenging the same. When the matter came up for hearing today, Mr. C.D. Chamir, Learned Senior Counsel, appearing for the respondent, submitted that certain developments has taken place during the pendency of the writ petition, and in view of the same, the writ petition can be disposed of at this stage. Mr. C.D. Chamir submitted that the Lotha Baptist Churches Association, which is the apex body of all the Baptist churches among the Lothas, through the letter dated 14/8/2021, has informed the respondents that Association's Executive Committee in its meeting held on 13 and 14 of August 2021 has recognized them as independent, full-fledged local church under the Lotha Baptist Churches Association with all liberty and privileges according to the association and accorded by the association, and accordingly the church's recognition certificate had also been issued. In view of the recognition by the apex body, the respondents who are already having their own church buildings will start worshipping separately in those buildings. Mr. N.Q. Lekam, Learned Counsel for the petitioners, admitted that the respondents have been recognized as independent, full-fledged churches by the Lotha Baptist Churches Association, but submitted that though they may be recognized as independent churches, they might still come to the mother church for worship, and in that event, there are chances of misunderstanding. That misunderstanding may once again crop up, which may create law and order situation. To this, Mr. C.D. Chamir, Learned Counsel, submitted that the respondents have their own church buildings and they have no intention to go back to the mother church for worship. In view of the submission of the Learned Counsels and the developments that are stated to have taken place, this court is of the view that for purpose that no purpose ought be served by keeping the writ petition pending. Therefore, it is disposed of with the direction to the Deputy Commissioner Oka to hand over the keys of the churches to the respective functionaries so that the parties may be able to worship in their respective church buildings and start functioning independently. Now, last paragraph will be important. In view of the disposal of this writ petition, the interim order passed earlier shall no longer have any force. So the interim order passed earlier is at page 88. This is relevant to show in whose possession the property was lying on 16/9/2021. Unoperative portion, Lordship will find.
Interim order dated 7/4.
Yes, 2021. Operative portion is at page 90. Bottom paragraph, last paragraph, page 90. The church case shall be retained by the sector church togetherers. So here also very clear, sector church togetherers, and shall upon the church on time, open the church on time for worship by both parties. All concerned parties shall strictly follow the above arrangements. This order comes into immediate effect and shall continue till the matter is resolved, the Okadam Baptist Church and the Lotha Baptist Churches Association. So this issue was recognized by the LBCA on 14/8/2021, already resolved on 14/8/2021. Now, what order has been passed in the review?
No.
District.
Interim order was, in the meantime, the order dated 12/2/21 passed by respondent 3 shall be suspended till the next reasonable date.
Yes.
So what is this order dated 12/2/21?
Yes, that is Deputy Commissioner's order. Lordship will find at page 90, just above which I have read.
Oh, okay. This is the order.
Order, yes.
12/2/21.
This is the order of the Deputy Commissioner. I am reading only the operative portion.
So this was suspended.
Yes. This was suspended, and by the disposal of the writ petition, it was vacated.
Vacated.
So the property was with us on this day. That is
The
16/9/2021.
church keys shall be retained by the sector church Jokitar.
Yes.
The-
Sector
But it
churches.
says WTBC. Sector Church Jokitar.
Sector Church. Ukaton Baptist Church is the mother church, main church. Because during this time, we were under Ukaton Baptist Church. Recognition was only on 14 August 2021. This order is on 12 February 2021. And DC has passed this order. They have challenged, and then
So
ultimately no
this
decision was
stayed,
arrived on
but
this.
after that it was vacated.
Yes.
Then review.
And then in the review, kindly come to page 111. This is the final order. Review. Before that, 106, the first order. And I will take your lordship to the operative portion, that is 109. 109, operative portion. Last paragraph. 109 has lordship.
Yes.
Yes. Last paragraph. Till the next date of hearing, status quo as on today, that is 23/9/2021, because this order was passed on 23/9/2021, page 106. Till the next date of hearing, status quo as on today, that is keys of the church building, including the keys of the apartments, quarters, etc. of 3 new independent churches, which were already handed over by the Deputy Commissioner, as per his circular dated 18/9/2021, shall continue to remain with the applicants, waived applicants, in the review, until further order of this court. So that will be relevant, because we are talking about the possession. Who was in possession on 16/9/2021? And the final order,
This order is dated 23/9.
yes, in the review, because they were trying to misinterpret the order passed by this honorable court, which was passed on 16/9/2021. So by this order, the honorable high court has clarified that keys of the churches includes all. And on that day, we were in possession of the property. Now, final order is at page 111. And it is a lengthy order, but I will take your lordship to the relevant portion, page 133. Here also the status quo order has been reaffirmed. Page 133. Yes, your lordship, got it? Page 133.
Yes.
And last paragraph, paragraph 11. This is the operative portion of the order. May I read, lordship?
Yes.
As stated above, in any case, this court is not the right forum to decide regarding the rights and the titles of the parties over the properties at this stage. They must first be decided by the civil court, having geographical and pecuniary jurisdiction as already stated. If the prayer of the petitioners in the review petition is considered and allowed, it would amount to stepping into the shoes of a civil court. It would also amount to doing something indirectly which cannot be done directly. As such, precisely stating, the parties will have to approach a civil court of competence having jurisdiction to decide their dispute over the properties. Accordingly, review petition and IA are disposed of with a direction that the parties should maintain status quo regarding the properties as on the day the order dated 16/9/2021 was passed in the writ petition till such time any of the parties move a competent civil court. See, so On the strength of this observation, the plaintiff has approached the civil court by filing the civil suit 1 of 2023. Along with the suit, they have filed an application under Order 39, Roll 1 and 2. And thereafter, no order was passed. And it came to bear only on 1st August 2026, after 3 years. And all these years, the property in question, we were in occupation, we were in possession. But the learned trial court has thought that as if we are a stranger and then occupying by in defiance of the court's order. I have taken Lordship's attention to the orders passed by the Honorable Court. Honorable Courts are very clear without any ambiguity. That is one aspect of the challenge with regard to the possession. Without understanding the possession, who is in actual possession, the trial court has given the temporary injunction restraining us to enter. Now, we cannot enter and worship. That is the whole problem. And for the last so many years, there was no problem with the congenial atmosphere. They were worshipping, we were also worshipping in our respective churches. So what was the harm to maintain status quo for all the parties to worship peacefully till culmination of the civil suit? Case may be proceeded. Another aspect, Lordship, because I want to be very clear how I am agreeing. Again, Lordship may kindly come to page 669, volume 2, I think. Rambion order. Here in Roman 2 paragraph, in the middle of the page, at page 669, the learned trial court has referred to an order passed by Executive Secretary, which has made an appeal to the three churches to restrain. Now, defendant number 7 is the Executive Secretary, LBCA. So, they are banking on this 9/2/2021. And then, since the Executive Secretary also...
Page 669.
669. Roman 2, middle page. Lordship will find an order of
9/2/2021.
passed by the, issued by the defendant number 7, that is the Executive Secretary LBCA. Unless the plaintiff number 1 consents, you cannot use. That word expression was used. Now, kindly come to page volume 1, 281. This is the pleading of respondent number 7 in the objection to
Volume 2, page?
volume 1, page 281. This is the pleading of the defendant number 7, that is the Executive Secretary LBCA, who said that I will read only paragraph 4. This will explain very clearly. Because without any authorization, he has written a letter, and that was meant to be the basis to arrive to a conclusion by the trial court. May I read, Lordship? That the statements made in paragraph 3F of the claim have been made by the referring to a letter dated 9/2/2021, written by the then Executive Secretary LBCA, that Reverend Dr. L. Chansau. The deponent was installed as the Executive Secretary LBCA on 21/9/2025. Since the said letter dated 9/2/2021 was issued by my predecessors, the deponent called for the records for perusal. Upon perusal of the relevant records, it was ascertained that there is no official record of the decision adopted by the Executive Committee entrusting the then Executive Secretary to issue the said communication. On a plain reading of the letter dated 9/2/2021, it is apparent that there is no reference about the decision taken by the Executive Committee. Therefore, it is evident that the said letter dated 9/2/2021 was issued by the then Executive Secretary LBCA as an appeal in his own individual capacity. That will be relevant. It is also pertinent to state that upon the further perusal of the relevant records, it was ascertained that after the then Executive Secretary LBCA issued the said letter dated 9/2/2021, the executive members of the three sector churches under Ukwadam wrote the letter dated 7/8/2021 requesting the then Executive Secretary LBCA for clarification and or elaborate the intent of the said letter dated 9/2/2021. In response, the then Executive Secretary LBCA, via his letter dated 9/8/2021, wrote to the pastors of the three churches stating in alia that in regard to possession of the properties, the only role he could accord is to make a fervent appeal to one and all to maintain Christian spirit by restraining oneself and await the generous and goodwill gesture from WTBC, Ukwadam Publishers. As stated in the preceding paragraphs, the MOA do not permit LBCA to interfere in the affairs of its members' churches' properties dispute. Therefore, the letter dated 9/2/2021 issued by the then Executive Secretary LBCA, led Reverend so-and-so, can be treated as a fervent appeal wrote in his personal capacity to the three sector churches under Ukwadam. So, they are governed by the MOA, Memorandum of Association, and the Memorandum of Association even do not permit. And when we come to the next volume, the volume 2, page 660. Contention of the opposite party, defendant number 4, 5, 6, and 7. How the Ladder Trial Court has decided. Page 660. Towards the bottom, Lordship will find paragraph 4.
Yes.
With bold letters. 7 is in the last. The respective learned councils in unison submits that since they have limited role in the present suit, they have nothing to submit in respect of the present case. This is contrary to the records and submission of the learned council at page 281, volume 1. They have file counter and submission was also made. But see, this is the finding. Therefore, Lordship, the imperial order is liable to be interfered with. At least the parties may be allowed to maintain status quo, and if any development, that may be subject to the final outcome of the case.
We will only say status quo.
Lordship.
Yes, an appeal
As on 16/9/2021.
The instant appeal under Order 43 Rule 1R of the CPC has been preferred against the impugned order dated 8/7/2026 passed by the District Judge Wokha, Nagaland in CMC number, or you just use full
Four
form,
of 2023.
in civil miscase number 4/2023 arising out of civil suit number 1/2023. So heard learned counsel for the learned senior counsel for the petitioner, assisted
Appellant,
by Mr.
Lordship.
Appellant, yes, appellant, assisted by Mr.
IMG.
IMG. Stop. Para. The subject matter of the instant case is the church building and the church building, as well as the pastor's quarters and the Sunday school, and then what else? And other ancillary structures with regard to the three fellowship churches of Samyan Baptist Church, SAMYAN, Samyan Baptist Church, comma, the Chufanzu Baptist, TCHUPHYANGZU Baptist Church, and the Tiyichan, TIYICHAN, Tiyichan Lota Baptist Church. The petitioners the are representing the three churches mentioned herein above. So, the appellants herein are aggrieved by the impugn order dated
8/7/26. 8/7/26. Page 648.
6 order dated 8/4/2026, passed in civil miss case 4 of 2023, which was an application under Order 39, Rule 1 and 2, read with Section 151 of the CPC, praying for grant of temporary injunction against the present appellants. Who were the defendants in this civil suit 1 of 2023. So, by issuing the said impugn order dated 8/7/2026, the learned trial court has observed that as on 16/9/2021, the suit properties were in the possession of the plaintiffs, and hence the current possession of the suit properties by the opposite parties / defendants number 1, 2, 3, 8, 9, 10, 11, 12, and 13, under bracket you write appellants, is in defiance of the judgment and order dated 24/2/2023, passed in review petition number 3 of 2021. Stop. In view of such observation, the learned trial court ordered by the impugn order that the opposite parties / defendants, under bracket appellants, were restrained from entering and carrying out any activities on the suit properties in the 3 sector churches. Stop. Para. Being aggrieved, the appellant has preferred the instant appeal on the ground that the learned trial court has arrived at an erroneous finding, as it is very clear from the record that on 16/9/2021, as on 16/9/2021, the appellants herein were in possession of the suit land, along with all the connected properties. Stop. The learned senior counsel for the appellants has also taken this court to the order dated what was the 16/9 order? Page?
16/9/21?
Yes,
That
16/9.
is page 1, 16/1. Page 100.
Yes, has also taken this court to the order dated 16/9/2021, passed in WPC 69 of 2021.
69.
Yes, 69. Passed in WPC 69 of 2021, wherein wherein this court has directed the Deputy Commissioner Woka to hand over the keys of the churches to the respective functionaries so that the parties may be able to worship in their respective church buildings and start functioning independently. Stop. Since this direction was misinterpreted by the by the
Plaintiff,
by the plaintiffs
applicants.
slash plaintiffs slash respondents
Yes.
slash respondents. The another review petition was preferred by the appellants herein,
Page one,
which in review petition 3 of 2021. So, Learned Senior Counsel submits that by order dated 23/9/2021, in review petition 3 of 2021, this court had what did I say? Order dated 23/9, nah? 23/9/2021 had held that till the next date of hearing, status quo as on today, that is the keys of the church buildings, including the keys of the apartments, quarters, etc., of the 3 new independent churches, which were already handed over by the Deputy Commissioner as per his circular dated 18/9/2021, shall continue to remain with the applicants until further order of this court. Stop. It is the submission of the Learned Senior Counsel that since 23/9/2021, the keys of the church buildings and the apartments, quarters, etc., had been with the appellant's hearing. Stop. Para. It is also submitted by the Learned Senior Counsel that the review petition 3 of 2021 was finally disposed of by this court on 24/2/2023.
Page 111.
Stop. Yes.
And the finding is at page 133, paragraph 11.
While disposing of the said review petition 3 of 2021, this court held that observed that this court is not the right forum to decide regarding the rights and titles of the parties over the properties at this stage, and that it has to be decided by the civil court of competent jurisdiction. The Learned Senior Counsel has specifically taken this court to the part of the order where this court has observed that the review petition and the IA are disposed with the direction that the parties should maintain status quo regarding the properties as on the day the order dated 16/9/2021 was passed in the writ petition, till such time any of the parties move as competent civil court. So, accordingly, it is evident that the appellants herein had been in possession of the suit properties from since 16/9/2021.
Actually, we talk about a possession on 9/2/2021.
Okay. Since 9/2/2021, which has been reaffirmed by
Yes.
by this court in WPC 69 of 2021. So, in view of the above submissions, Learned Senior Counsel prays that that this appeal may be admitted and the where is your prayer portion? Page.
IA, separate IA has
Oh,
been
separate
filed.
IA has been filed.
Yes.
Maybe admitted, huh? So, para. Issue notice returnable in 4 weeks. The Learned Counsel for the
State
appellants,
Council is represented.
they are also party. Okay.
Yes.
Okay, Learned Additional Advocate General Mr. M. Timson accepts notice on behalf of respondents number 3, 4, and 5. So, the appellant shall take steps for service on the respondents number 1 and 2 by speed post as well as usual process within 3 working days from today.
To avoid further complications, records may be called for, Lordship, from the time.
No, but we have not admitted as yet. When we admit, we will call. Okay, and where is the IA? Okay. Okay, in IA 159, huh? The instant application has been filed praying for an interim order suspending the impugned order dated 8/7/2026 passed in CMC 4/2023 arising out of civil suit 1 of 2023 passed by the District Judge Boka. Stop. The instant application has been preferred by the applicant's hearing praying for suspension of the impugned order during the pendency of the main appeal MAF number 1 of 2026. Stop. Third learned counsel, learned senior counsel for the applicant, Mr. C.D. Jamir, assisted by Mr. I. M. Chin. Stop. Learned here also, same, no? Same respondents. The state of Nagaland is represented by, the respondents number 3, 4, 5 and 6, 3, 4, 5 are represented by the learned additional advocate general, Mr. M. Timso. The counsel for the applicant shall take steps for service on the respondents number 1, 2 and 3 by speed post as well as, 1, 2, 3 and 6 by speed post as well as usual process within 3 working days from today. Stop. In the interim, the impugned order dated 8/7/2026 passed in CMC number 4/2023 is suspended.
And Lordship, any development shall be subject to the outcome of the suit. If there is any development by any of the parties.
Is there some
Because,
development going on?
Painting is required because to worship with a high enthusiasm, the surrounding should also be equally good. Now, it is in a dilapidated condition, we want to paint it, but then when there is a status quo, we cannot touch also, as law-abiding citizens. So, any development by any of the parties may be subject to the final outcome of the suit.
Okay. Any development on the suit properties by any of the parties shall be subject to the outcome of the suit, okay, main suit. Okay. And okay. List after 4 weeks. No?
Towards the beginning of the order, Lordship may have said the impugned order is 8/4/2026. It is 8/7/2026.
Oh, 8/7/2026.
And then in the main case, the notice have not been issued to respondent number 6. That may also be.
Okay, so it will be 1, 2, 3 and 6.
Yes.
1, 2, 3 and 6 in the main case.
3 is represented by State Council. 1, 2 and 6.
1, 2 and 6. 1,
Yes.
2 and 6.
3 is represented by NTMC.
1, 2 and 6. Yes.
The next case is in the counterclaim. In the counterclaim, virtually while deciding our IA, that is application under Order 39, Rule 1 and 2, virtually entire counterclaim has been decided. That finding is arrived basing on the facts which I have narrated, Lordship.
So on this also we'll issue notice.
Lordship. And here also I is there.
Here also it will be the same, but then you just say this will be
Actually, Lordships, when a counterclaim is filed against in a main suit, it should club together
It should
and
be
go
clubbed
as one.
together, huh.
But then it was of the opinion of the trial court that no, it has to be registered separately. That's how
That's why
all
I'm
these
wondering,
problems.
because usually it is one case
Yes.
only.
But then the learned court below did not agree to that.
It will
So
become part of that main
we are
suit.
at the
It's just a
receiving
repetition.
end. Yes. Otherwise, it should be a part of the main suit. But then the learned trial court wanted to get it registered separately as a separate case, which I feel that this may not be proper. Anyway, it has been done
Because
in that
when
manner.
counterclaim is filed, it's always part of the same, it
Yes,
becomes part
yes.
of the same civil suit.
Yes.
Okay, just say
What is our say?
the instant the appeal has been referred under order 43 rule 1R of the CPC against the order dated 8/7/2026 passed by the district judge Wokhan Nagaland and IA civil number 13 of 2025 arising out of counterclaim number 1 of 2025 by which the counterclaim of the appellants was dismissed.
Yes.
Was dismissed.
Not
Not
injunction.
dismissed, but, was not considered.
Yes.
Was not considered.
Dismiss and contest without any debate of me.
Where is the impugned order here?
Page 174. Finding is page 191. Lordship may kindly come to 189. Just above issue number 2. Issue number 2 is shown in the bold letters distinctly. 189. Just above that, 4 lines above issue number 2, towards the bottom. The applicants plaintiff to the counterclaim have failed to make out the prima facie case in their favor, warranting trial. So, virtually everything has been decided. While deciding the injunction application,
And by
entire
which
counterclaim has been decided.
the counterclaim filed by the appellants was dismissed on contest as being devoid of merit. No? As being devoid of merit. So, Learned senior counsel submits that on the learned trial court by deciding the IA civil in such manner has already virtually decided the entire case and has stated that the applicants herein had failed to make out a prima facie case warranting trial. Okay. So, issue notice here also same thing, huh? Returnable in 4 weeks. Then notice also will be 1, 2, and 6. No. Yes, 1, 2, and 6. And Learned Additional Advocate General, Mr. M. Tim Song, accepts notice on behalf of respondent number. No. Here, government is not the party, isn't it?
government is not a party here.
Don't say, huh? This is only 1 and 2. So, shall issue notice and take steps on respondent number 1 and 2 by speed post with as well as usual process within 3 working days. And then in the IA also. Same order, but the case number will be different. Here it will be IA civil number 13 of 2025, and the date of the order same, no?
Yes.
Date of the order is There is no date given in the order here. Anyway, date of the order is 8/7/2026.
It's given in page number 10.
Oh, okay, yes, 8/7/2026. Yes. Then the impugn order shall remain suspended here also, and then issue notice, returnable in 4 weeks. Same here also, respondent number 1 and 2, okay?
Delay applies.
For admission, item number 6.
Please, Your Lordship.
Yes.
Lordship, in this matter, will be filing a rejoinder. So, if Your Lordship may kindly grant us 3 weeks.
To file rejoinder.
Lordship.
Learned counsel for the petitioner, Mr. Sarin is present. Stop. Learned counsel, Miss.
For respondent
is
number
present for respondent number 1. Learned counsel for the petitioner submits that he would be filing a rejoinder to the counter affidavit filed by the respondents and prays for 3 weeks' time to file the same. So please after 3 weeks as prayed for.
For admission, item number 13.
Lordship, in this matter, the charge sheet has been filed, but charges are yet to be framed. Lordship, since in a bail application, merits are not to be gone into, but still then, since it is important to at least have an overview of the nature and gravity of the offence.
Charge sheet filed.
Charge sheet has been filed.
Do you have a copy?
Your Lordship, it is Your Lordship, actually, when the matter came up, like, the Lordship has actually directed for production of CD.
Yes.
Going through, I find that, like, charge sheet has already been filed, and it is annexed in the petition only, Your Lordship.
It is in the petition itself. I have annexed in the petition.
But it was never pointed out.
Yes, Your Lordship, I thought, I had mentioned it in my synopsis also, but it so happens in my synopsis, I have not made a mention. It was done in a hurry. I apologize for it. If Your Lordship may go to
Page 35, is it? The charge
yes,
sheet?
page 35. This is the charge sheet. So I'll take Your Lordship to the page 36. Steps taken during the course of investigation. If I may read. Alleged accused reported at police station on 13/5/26 at around 8:40 hours. Subsequently, he was taken to NHAK for medical examination, report enclosed. During brief examination, alleged accused stated that he proceeded to the construction site in the afternoon where he had alcohol with a friend. He does not remember how he entered the house and how he acted on assaulting the girl. He doesn't know the victim or recall her face. That he had not have any intention or specific purpose. Later, he learned that victim is from Konyak community and the guardian is from Eastern community. Upon duly informing the grounds and rights of arrested person, alleged accused was formally arrested and due intimation was given to family members in written. Copies enclosed. Arrested accused was produced before the court on 13/5/26 with prayer for 72 hours police remand, and the same was granted on 15/5/26 upon completion of custodial interrogation. Accused was forwarded to judicial custody with prayer for 15 days judicial remand, and has been extended time to time upon several submissions for the extension of accused judicial remand. Medical re-examination of the primary minor victim was arranged at NHAK, and the medical report states mild swelling over nose bridge. X-ray report shows discontinuity in nasal bone. ENT specialist was consulted through phone and advised ENT review within a week. The primary minor victim was examined in the presence of her guardians. She stated that on 12/5/26, around 7:30 p.m., the family, victim 1, Ning Yong, cousin Holip, 13 years, cousin Hong Lumong, 5 years, and cousins Yimdo were home while some of them were having dinner, and she was inside the kitchen. Out of nowhere, an unknown person came inside the kitchen and started throwing kitchen items, spilled waters inside the kitchen. She asked him why did he come to their house and is disturbing them. Alleged accused replied and asked who are they to ask him staying at his village, showing off. He started physically assaulting her by grabbing her hand and pulls her clothes near her chest area. He then punched her on her head and nose several times, for which she had nose bleed. Victim 2 corroborated the occurrence and stated that she witnessed the accused assaulting the minor victim and that she herself was assaulted when she attempted to intervene. Victim 3 stated that he witnessed the accused touching the chest area of the minor victim against her will and thereafter physically assaulted her when he attempted to rescue the victim. He was also assaulted by the counsel. The complainant stated that on receiving information from his wife stating that an unknown person had entered the house, attempted to rape the minor victim, and also physically assaulted other family members, he immediately went home. Since the minor victim was injured, they took her to hospital and he filed the FIR. The place of occurrence was visited on 14/5/26. On reaching the PO, the victim was found resting in her bed. Upon examination, she was found to be physically weak. PO was verified and documented through photography and videography. Upon verifying the PO, it was learned that alleged accused broke some household items and belongings of the minor victim. Accordingly, the properties were seized under proper seizure memo in the presence of witnesses. Subsequently, available witnesses, Vibizo Lasumo, 24 years, was examined, who stated that on the day of the incident, somewhere in the afternoon, while he was helping his brothers in unloading the pickup truck just outside the BO, accused Sienio came alone from his bike and he was already drinking alcohol, though not very drunk, and in his senses. Not long after his brothers went for second trip, Sienio friends, namely Kizangoto and Vilaba, came by pickup car. By the time his brothers returned from second trip, Sienio was already very drunk, and after they unlocked the truck, they all went to their home. Not long after he came home around 7:30, Sienio, who was already very drunk, came calling them, but since he was drunk and he has a history of disturbing people when being drunk, they did not respond to him. They thought he left, but he must have went to the place of the victim. After some time, he could hear sounds from upstairs, so he came out to check. He did not see the accused assaulting the minor victim, but when Yolong, victim 2, was going inside the room, accused went after her and kicked on her leg. Subsequently, people started gathering and they were able to control alleged accused. He was drunk and was not ready to listen to anyone. On thorough interrogation, alleged accused stated that on the day of the incident, somewhere in the afternoon, since his friends were working at a construction site near Kisama Gate, he went there after he bought MC Ram 1 bottle with ₹500 on going to the location. There were people working, including Bibizo, Masilato, Tichangozo. After some time, Masilito and Tichangoto left to pick construction materials. Not long after they left, his two friends, Bibi Kichangoto and Vilabo, came by pickup truck and they talked for some time. After they left, Bibizo was not there, so he went inside the house searching for him. When he entered the kitchen, he saw victim 1 sitting. He started hitting her without any reason. Grabbed her collar with his left hand and punched her head with the right hand. He remembers hitting her 2-3 times on her face, then kicked her on her chest and stomach 2 times. Further stated that when people started gathering and tried to stop him, he tried to hit them. He remembers Vipizo coming to stop him among some other people. After going home, he went to Kisama with his cousin Atozo and they had alcohol again. After reaching home, on being told that his uncle Kikinio took the victim to Bethel Hospital, he took his bike and went to the hospital around 1-2 a.m. to see how the victim was. On reaching hospital, he entered the hospital, checked some rooms and asked some people around And since he did not see anyone from his village, he went out of the hospital, during which he saw his uncle Kitinio, who said that the victim is not very serious, so they left for village. In the process of investigation, victim 2 was taken to NHAK for medical examination. The medical report stated bruising 4 cm diameter on right thigh. Medical report enclosed on reinterrogation of alleged accused. His statement corroborates with the previous statements. He further stated that after consuming alcohol, he frequently becomes aggressive and develops an urge to fight and assault people. On that day also, after getting drunk, he started having itchy hands and felt like starting a fight and to hit someone. Prosecution witness Masilatu Zasimo, 27, stated that on the day of incident, while he was working with his brothers, accused came and he was already drinking. Later he saw him with some of his friends, but he did not speak to them, and after reaching home, he was informed that accused was disturbing some people, and on reaching the PO, he informed the colony youth. Friends of alleged accused, Kizangmutu Chitso, 31 years, and Vilaba Buro, 35 years, on examination stated that they met accused near the BO while coming back to village. Accused was already drunk, and since he stopped them and came inside their car and was not leaving, Vilaba made an excuse of going for nature's call and went home by foot, while Kizangotu also left after Masilato came back. They stated that they used to mingle with alleged accused some years back, but since he has a habit of disturbing people after getting drunk, they stopped going out with him. Cousin brother of alleged accused, Atozo Zasimo, statement corroborates with alleged accused, stating that on the night of the incident, they went to Kisama to drink alcohol, after which alleged accused took his bike and went to hospital. So, Your Lordship, if Your Lordship may go through the whole thing, it was a case where the accused was drinking the whole day. And unfortunately, the accused, as the evidence of his other friends are clear. Once he drinks, he goes straight.
He starts bashing up people.
He starts fighting, because of which his friends don't stay away from him. So here, in this case, unfortunately, although the act which he has committed is condemnable and very vicious, but it was because of the alcohol-induced craziness, he went and committed the offense of beating up the victims and her relatives. But from the fact findings of the investigating officer also, it is very clear that there is no sexual assault, no sexual intention. Intention cannot be even inferred from the facts of the here, Your Lordship. But it will be
But this court
yes.
at this
So
stage
at this
cannot
stage,
go
yes.
in the
And
bail.
even during the framing of the charges, these issues will be raised.
Yes.
But
And you can always
just-
pray for dropping the
yes,
charge also.
But just to give an overview, it was a pure case of drunken behavior. So far as the charge sheet is concerned.
You were
The
arrested
facts.
on
Yes, I was
13/5.
arrested on 13/5. I surrendered myself. When I was sober, I went personally to the police station and I was arrested. And since then, I have been in the custodial, judicial custody now.
And when is it fixed for framing of
Your
charge?
Lordship, I am yet to get any information. The bail was moved on. Your Lordship, the bail
But at the time when bail was moved,
Yes.
the charge sheet was not
Charge sheet
filed.
was not filed. Charge sheet was not filed. And learned court trial, the learned CJ, special judge, Pokso also, based on the ground that he is likely to abscond and he may interfere with the investigation. So on that ground alone, rejected the bail. And now, Your Lordship, the petitioner is to appear and interview.
When?
Entrance examination tomorrow at the ADI for training. Your Lordship may.
Is it stated here in your
Page 28, yes. Page 28, the whole
No,
ticket is.
in your pleadings?
In my pleadings, I have made statement in paragraph. Paragraph 7, Your Lordship.
Yes, what do you say?
Please, Your Lordship.
Yes.
The Lordship, as I have said, the bell has been moved before this Lordship,
Yes.
after the charge sheet has been filed. So, Your Lordship, at this stage, granting bell, I think it will not be proper.
No,
Why,
he
Your
has,
Lordship?
he has to appear in exam tomorrow.
Yes, Your Lordship, I'll come to that, Your Lordship, I'll come to that. However, Your Lordship, as far as the case is concerned, Your Lordship, the petitioner, the counsel for the petitioner has fairly submitted that he's in the habit of getting drunk, and when he gets drunk, then he acts unreasonable, Your Lordship. Now, if taking the submission of the petitioner counsel, if he has to be granted bail, Your Lordship, we never know. He might, and the victim is in the location, same location. They are in the same village, and it's the victim is under the apprehension. We got the report from the IO also. Since the charge sheet has already been filed, so I felt that like report need not be required. However, I told the IO to give me the precise report, since the charge sheet has already been filed, to give a view.
Who's appearing? Z. Kulno.
Please, Your
Yes.
Worship, this petition has been filed challenging the order passed by the Sessions Court.
Acha, wasn't this case supposed to be listed along with that yesterday's case?
Yes, clubbing was there. But however, in this matter, Your Worship,
Oh, but this is coming up for the first time today.
it was fixed, it came up on Friday also. And it was fixed today. Learned PP.
File this incident. So let it be listed together.
Worship, here I'm praying for staying the
No,
operation.
no, that cannot be stayed. When the order is already passed in the contempt and notice is issued, how can you stay?
Because Your Worship, basing on this order, some subsequent orders have been passed for release. And until this one is stayed, I cannot even challenge the interim order, Your Worship, because the balance of convenience will be with the petitioners.
No, see, what happened was because of the violation of this order,
Yes.
that writ petition was filed, isn't it?
No, Your Worship. They are in the writ petition. They are challenging the entire process, Your Worship. The
No, no,
seizure
no.
manner.
In
And
this, by this order, by this impugn order, the impugn order dated
Dated 12/3/2006.
So see, by this order, the 570 bags of areca nuts was released on Zima.
Yes.
But it was not complied with.
Yes, Your
It
Worship.
was not complied with. That's why they filed that WPC before this court. And in that WPC, we gave a direction to upholding this order, this Zima order. Then further, it was not complied with. So the contempt petition was filed. So if this is stayed, then the entire proceedings, WP, the contempt, everything will go. How can that be?
Because, Your Worship, we are challenging the jurisdiction here in this. Because without challenging this one,
No, you can challenge, but there can be no stay. That's what I'm trying to say.
okay.
It's okay, you can challenge if you want. That is, notice is already issued, I think, as far as the petition is concerned, isn't it? That is the fact. Yes. So this court has already given a direction to list it together.
Yes.
When was that? After 4 weeks, or
After 2
was
weeks.
any date given?
It's not been fixed. After 2 weeks.
After 2 weeks.
Yes. By order dated 2026 in WPC
42 of 2026.
42 of 2026, this court has directed the instant petition to be listed along with the said WPC after 4 weeks. So accordingly,
After 2 weeks. Yes.
after 2 weeks. Accordingly, registry is directed to club this case along with WPC 42 of 2026. Yes.
Bless you.
For orders, item number 21.
Lordship, this instant IA is filed for condemning the delay of 430 days against a judgment dated 19/7/2024 passed by the MST Dimapur Nagaland Lordship. Lordship, the brief fact of the case is that on 22/8/2015, while the deceased was returning home in an auto rickshaw bearing registration number.
Respondents are represented. Are you filing objection or you're filed? Filed.
Well, the deceased was returning home in an auto rickshaw bearing registration
No,
number.
just come to the grounds for the delay.
Page 5, para 5.
Para 5.
5. Yes. Para 6, Your Lordship, I'm sorry.
Yes.
That the appellant has a divisional office at Dimapur in the state of Nagaland. It has a regional office in Gauhati, Assam. That the appellant received the judgment dated 19/7/2020, which I have annexed in Annexure A, page 14, Your Lordship, through their divisional office at Dimapur dated 22/07/2024, which I've also annexed as Annexure 2, page 32, along with the legal opinion revised on or received on 23/7/2024 to the regional office for approval, advice in recommending the appeal on 24/07/2024, which I've also annexed as Annexure 3, page 34, Your Lordship. Through mail, the regional office Gauhati approved in recommending the appeal and returned the entire file in original for appeal before this Honorable Gauhati High Court Kohima bench on 25/7/2024, which I've annexed as my Annexure 4, page 35, Your Lordship. On receiving the file by the divisional office at Dimapur and following up with the procedure of the company on deciding whom to appoint, accordingly the divisional office Dimapur appointed an impanel counsel on 29/7/2024, which I have annexed as Annexure 5, page 36, to file an appeal against the judgment in order dated 19/7/2024, Your Lordship, passed by the learned tribunal MST Dimapur before the court. However, due to the lackadaisical manner of the council, not materialistic, causing a delay of 293 days, and during the period of 293 days, the company has contacted the concerned and penal counsel several times through telephone, to which the council has assured the company on several conversations through phone that it is in process. So the company trusted the council in good faith, and in the meantime, the claimant respondent number 1 and 2 filed an execution case number 03/2025 before the MST Dimapur, which the company received the order dated 28/5/2025, which I've annexed as Annexure 6, page 37 on 02/06/2025. Then after receiving the company contacted the council regarding her legal opinion, to which no response was received from the council regarding the appeal nor the execution. So the company again on 16/5/2025, which I've annexed as Annexure 7, page 40, Your Lordship, appointed another impanel counsel, but the impanel counsel caused a delay of 97 days by giving assurance to the company through telephonic, and to which the company trusted the counsel in good faith. But since there is no any news about the filing of the appeal, even after 97 days, the company decided to appoint another impanel advocate. Para 7, Your Lordship, that the company deputed a new impanel counsel and forwarded the entire claim file on 28/2025, which I've annexed as Annexure 8, page 43, that after receiving the file by the council, completed the instant MAC appeal and forwarded the MAC appeal petition for verification and to obtain signature and necessary formalities on 17/07/2025. And during this process, there has been a delay of 28 days. This delay was caused because the council had some health issue, due to which the council took some time in filing the appeal. The instant appeal was filed on 22/9/2025, Thus, there has been a delay of 430 days in filing the instant appeal, and the delay has been caused due to the reasons stated above and not to willful negligence or default on the part of the appellant company. As such, the delay in filing the appeal may be condoned as by going through the statement above, a total number of 418 days was caused by the impaneled counsel whom the present appellant appointed. It has been stated in Ram Kumar Gupta and others versus Har Prasad and another SSC case 391 2010-1 that the contesting party should not suffer for the lapses on the part of the counsel. Relevant portion is in para 11. The case that was made out by the appellant for restoration of the writ petition was that the learned counsel for the appellant Shri Gupta could not appear before the learned judge of the High Court at the point of time. He was designated as the additional Advocate General of the state. For that reason, it was not possible for him to appear at the time of hearing of the writ petition as well as for restoration of the writ petition. Keeping this fact in mind and the fact that the appellant could not be represented at the time of hearing of the writ petition, we feel it appropriate to restore the writ petition to its original file in order to give an opportunity to the appellants and to contest the same on merits. And in Rafiq and another versus Munshi Lal and another SSC case 788-19812 Pair 3. The disturbing feature of the case is that under our present adversary legal system, where the parties generally appear through their advocates, the obligation of the party is to select his advocate, brief him, pay fees demanded by him, and then trust the learned advocate to do the rest of the things. The party may be a villager, may belong to a rural area, and may have no knowledge of the court procedure. After engaging a lawyer, the party may remain supremely confident that the lawyer will look after his interests. At the time of hearing of the appeal, the personal appearance of the party.
Basically, you are trying to say that it was the fault of the counsel.
And also
The
that,
delay.
Your Lordship, if I may, Your Lordship, excluding the 90 days, it's 340 days, and also a total number of 67 days in between. There was holiday, winter breaks, summer break, and all those holidays was also there. So excluding everything, there is 173 days of delay, Your Lordship.
Then why you have given 430 days in your application? Yes, anything?
May I please, my lordship? First of all, your lordship may be pleased to appreciate the fact that the present appeal was filed after the respondent, claimant respondent filed an execution petition on 28/5/2025. They have filed this appeal on 22/9/2025.
22/9/2025.
Execution was filed on 28/5/2025. Execution 3.
28/5/2025.
They have been sleeping over the judgment for more than 1 year, 65 days. That is my first point. Secondly, in respect of the delay, there is no proper explanation in regards to 293 days in connection with the impanelment of first counsel. And 97 days in respect of impanelment of the second counsel, and 28 days in respect of impanelment of the third counsel. Your lordship may also appreciate the fact that there is not even a single piece of document annexed in this IA regarding their communication with the panel advocate.
With the counsel.
Now they are trying to entirely blame on the counsel. But the appellant was not diligent enough to inquire to their panel counsel about the status of preparation of the appeal.
they are the mighty insurance company. They have their own separate legal department to look into this matter. And there are several ways to communicate with the panel counsel also. WhatsApp, SMS, phone, email, everything. But there's not a single piece of document annexed in regard to the communication with the panel counsel in all the three respective counsel. In addition to that, Your Lordship, now admit that there's 293 delay in respect of the first counsel. So, after engaging the second counsel, they should have taken proper step and care in communicating with the counsel, with the second counsel to file the appeal on time. But here again, they were sleeping over the judgment. As such, there was a delay of 97 days, my lord. In addition to that, they have engaged the third counsel also. But that also they have taken 28 days delay. And there is no sufficient explanation in this regard.
Your Lordship, if I may, for the 28 days delay, if I can submit privately documents regarding my health issue, Your Lordship.
First counsel or second counsel?
No, it's the
for the third counsel.
Yes, Your Lordship.
I may be allowed to continue, my lord.
Then?
Now, the entire explanation and the annexure, annexed in this IA, is based on administrative formalities and movement of file and handing of file from one advocate to another counsel. Now, the authorities relied by the appellant in this IA relates to a writ petition, restoration of writ petition, and other appeals. But Your Lordship may be pleased to keep in mind that this instant application relates to a judgment passed under a beneficial legislation. The claimant has been waiting for 1 year, 65 days without any response. And only after filing an execution application, they have woke up from the slumber and filed this instant application. And they are trying to blame entirely on the impaneled advocate. Where is the communication between them? In support to my submission, I like to rely on the authority 2024 SCC Online SC 3380. SCC Online SC 3380. My lord, at para 10. I may well to read. It appears that the entire blame has been drawn on the head of an advocate who was appearing for the petitioner in the trial court. We have noticed over a period of time a tendency on the part of the litigants to blame their lawyers of negligence and carelessness in attending the proceeding before the court. Even if we assume for a moment that the concerned lawyer was careless or negligent, this by itself cannot be a ground to condone long and inordinate delay, as the litigant owns a duty to be vigilant of his own right and expected to be equally vigilant about the judicial proceeding pending in the court initiated at this instant. The litigant therefore should not be permitted to throw the entire blame on the head of an advocate and thereby disown him at any time and seek relief. So, in this instant application, they have given the appointment to the impaneled counsel, and that's it. They have done their part. They did not take any proper step, caution, or inquiry with the panel about the status of the appeal, and they were sleeping over the judgment, and it was only after the execution application was filed before the trial court, they have woken from the slumber, and they have filed this instant application. My lord, I may be allowed to place on a case IA number 147 of 2024, passed by this honorable court. Having considered the submission of the counsel of the parties in upon going through the application under Section 5 of the Limitation Act, this court is of the view that the entire explanation given by the application is based on administrative formalities and movement of files from one table to another, which are not valid ground in view of the advancement of modern technology, which allows speedy communication even from far-flung areas. This court has also observed that there is no explanation at all with regard to 249 days in between the judgment between 7/5/2023 and later dated 22/1/2024, which the panel advocate has written to the claims department office forwarding its legal opinion. Similar observation has been made by this honorable court in IA 97 of 2024. In this IA 97 of 2024, this honorable court was also pleased not to condone 47 days because no proper explanation was given and no sufficient cause was there in that application. Therefore, in conclusion of my submission, I humbly pray before this honorable court that the instant application may be dismissed, being given of marriage, and no sufficient cause or explanation is shown by the appellant.
Lordship, if I may give a submission for the interest of justice. Your Lordship, in my main appeal, I have genuine grounds as stated in para 6, page 3, where the auto rickshaw was registered only after the accident, Your Lordship.
No, at this juncture, we will not go into the merit of the case because the applicants have not been diligent at all. The instant application under Section 5 of the Limitation Act has been filed, praying for continuation of delay of 430 days in filing the connected MSc appeal against the impugned judgment and award dated 19/7/2024, passed in MSc case number 112 of 2016 by the MSCT Dimapur. So, her learned counsel for the applicant, Ms. Kim Penyu, also heard Mr. Imi Wabang for the claimant respondents. Mi Wabang. For the claimant respondents number 1 and 2. So, by filing the instant application, the applicant/insurance company has prayed for a continuation of delay of 418 days in filing the connected MSc appeal on the ground that the appellant has a divisional office at Dimapur, Nagaland, and it has a regional office in Gauhati, Assam. It is stated that the applicant had received the judgment dated 19/7/2024 through their divisional office at Dimapur on 22/7/2024, along with the legal opinion, and the same was forwarded to the regional office on 23/7/2024. No, wait. That the appellant had received the judgment dated 19/7/2024 through their divisional office at Dimapur on 22/7/2024, along with the legal opinion which was received on 23/7/2024, and the same were forwarded to the regional office for approval to file the appeal on 24/7/2024 through email. The said communications have been enclosed and annexed by the applicant as annexure
2 and 3, Your Lordship.
annexure 1, 2 and 3 na? Annexure 1, 2 and 3. Stop. It is also stated that the regional office Gauhati approved and recommended for filing the appeal, and this entire file in original was returned on 25/7/2024. On 25/7/2024. Stop. Upon receiving the file by the divisional office at Dimapur, the steps were taken, and accordingly, the divisional office Dimapur appointed an impaneled counsel on 29/7/2024. Impaneled counsel on 29/7/2024, requesting the said impaneled counsel to file an appeal against the judgment dated 19/7/2024. Stop. However, it is stated that due to the negligence of the counsel, impaneled counsel, nothing was done, thereby causing a delay of 293 days. And that during the period of 293 days, during the period of 293 days, the applicant had contacted the concerned impaneled counsel several times through the phone, to which the counsel had assured the company slash applicant that the appeal was being prepared and that it is in the process. Stop. The applicant states that the applicant states that in the meantime, the claimant slash respondents 1 and 2 filed an execution case number 3 of 2025 before the learned MSCT Dimapur, which the applicant received on 2/6/2025. Stop. But after receiving the said order dated 28/5, after receiving the order dated 28/5/2025, passed in the execution case. No, sorry. 28/5/2025 in the execution case number 3 of 2025, on 2/6/2025. The applicant again contacted the counsel regarding her legal opinion. Stop. Regarding her legal opinion. However, no response was received from the counsel regarding the appeal nor the execution case. Stop. It is further submitted that the applicant on 16/5/2025 on 16/5/2025 appointed a second impanel council. But the second council, impanel council, also caused a delay of 97 days by giving assurance to the company through phone. Stop. Therefore, after the 97 days, the applicant decided to appoint a third impaneled advocate. Stop. Para. After the decision to engage a third impanel counsel, the applicants forwarded the entire claim file to the third impanel counsel on 28/2025. Stop. After receiving the file, the present counsel / third impanel counsel completed the process of drafting the connected MSC appeal and forwarded the same for verification and signatures on 17/9/2025. And during this process, there has been a delay of 28 days, and the same had been caused because and the said delay of 28 days had been caused because the council had some health issues. And finally, the connected appeal was filed on 22/9/2025. Stop. Thereby causing a delay of 430 days. Stop. The Learned Counsel submits that the delay has not been caused by the inaction or negligence of the applicants, but due to the delay caused by the impanel councils. So, Learned Counsel, in order to support her contentions, has relied on the case of Ram Kumar Gupta and others versus Har Prasad and another, reported in 2010 1 SCC 391. Is it 2010 1 SCC 391? Stop. Learned Counsel therefore praised that the delay of 430 days, 430 or 418?
430, Your Lordship.
430 days may be delayed, may be condoned. Stop. Para. Per contra, the Learned Counsel for the respondent / claimants, Mr. Mi Wabang, submits that the impugned judgment was disposed. The impugned judgment was passed on 22/9/2025, and the execution petition was filed on 28/5. Wait. That the execution petition was filed by the claimant respondents on 28/5/2025, and the MSC appeal, the connected MSC appeal was filed only on 22/9/2025. Stop. He has also submitted that even though the applicants have stated that the brief of the case had been given to the first impaneled counsel on, when was that? Impaneled counsel on 29/7/2024, the applicants have not shown any communication between the applicants and the council, and they have not pursued the matter diligently with the engaged counsel. Stop. He has stated that he has also submitted that even after the second impanel counsel was appointed on 16/5/2025, the applicants have not made any efforts to communicate with the engaged counsel, with the second engaged counsel, and there's nothing on record to show that such communication had been made. The learned counsel, by relying on the case of Rajneesh Kumar and another versus Ved Prakash, reported in 2024 SCC Online SC 3380, submits that the applicant should not be permitted to put the entire blame on the counsel, as the applicant himself had been negligent and that the case relied upon by the applicant in the instant case is not applicable, as the same was passed in a writ petition, whereas the instant case relates to a beneficial legislation such as the Motor Vehicles Act. Stop. Learned counsel has also relied on the order of this court dated 23/6/2025, passed in IA Civil 97 of 2024, and order dated 10/3/2025, passed in IA Civil 147 of 2024. So, learned counsel submits that the facts and circumstances in the said IAs are similar in nature to the present case, as no proper explanation has been made by the applicants for the delay of several days after the brief was handed over to the counsel for the applicants. Or you can say first and second counsel of the applicants. So, in view of such submissions, learned counsel prays that the instant application may be dismissed. Stop. This court has considered the submissions made by the learned counsel for the parties and has also perused the pleadings, specifically the explanation given in paragraph 6 and 7 of the application, of the instant application. Paragraph 6 and 7, no? It's in 7 of the 6 and 7 of the instant application. Stop. Regarding the correspondence between the divisional office Dimapur and the regional office at Gauhati, the applicants have annexed the relevant letters and the emails in the instant application. Stop. As the entire application is based on the fact that as the entire explanation of the applicant is based on the fact that the counsel, impaneled counsel, had caused the delay, it was incumbent on the part of the applicant to have shown the communication between the applicants and the counsels, and prove that such communications had been made by the applicants, and that in spite of such communication, the counsel had caused the delay. Stop. However, upon going through the entire application, there, the- there is nothing to show that the applicants uh, had communicated with the first engaged counsel or the second engaged counsel, except for a sentence saying that the counsel had been had been contacted over the phone. Stop. Therefore, there is no material on record to show that the applicant had been diligently pursuing the matter with the first engaged counsel or the second engaged counsel, respectively. Stop. Consequently, this court is of the view that the applicant had not pursued the case diligently, and that and therefore the instant application is dismissed.
Lordship,
Yes.
if I may be allowed to withdraw the statutory deposit of 25,000, Your Lordship. Because once the claimant approached
the
complaint,
applicant
they
is
get
allowed to withdraw the registry shall allow the applicant to withdraw the statutory deposit of rupees 25,000. The other matters, you just say pass over, huh? Who are there for the other matters, remaining matters? Yes.
Lordship, for item number 22, if I may be allowed to take substitute notice upon the respondent through newspaper publication.
Let it come up another day, there's no time now to write the order. So, pass over due to paucity of time. Tomorrow or day after?
Lordship.
Yes.
In respect
Oh, yes,
of
yes.
my item,
Yes.
8, 9 and 10,
Yes.
since due
What
to
to
the
do?
constraint of time and
Friday.
paucity,
Day after tomorrow.
Friday.
Yes, first, day after tomorrow
First.
is Thursday. That's first execution item. On Friday.
Okay. Your item, just give your item number.
8, 9 and 10.
8, 9 and 10, no? Thursday. As first, this is for admission.
Yes,
Admission hearing.
admission,
As
yes.
first item, huh?
My lord, to this paucity of time, you kindly be reflected because I am representing an institution.
Yes. Today's order also will be passed. We'll say due to paucity of time, the matter may be listed on Thursday will be 23/7 as first item in the admission.
Let the interim
And
continue.
the other cases also due to paucity of time, no? At least pass on.
Let the interim continue.
The interim order shall continue to the next.
Thank you very much.
I can fill this. Rest of the items next order on the show.